against my interest money. Therefore, my lord, I have already filed one, my lord, senior application, my lord, for having me, my lord, in this matter, my lord. So I am saying, my lord, this matter, I am ready to step forward. Keep problem.
I take mention for listing of the letter.
First March.
Yeah. Project B, item which was a part third matter. If in the first half it is not, I pray that maybe taken up at 2 because from tomorrow I am on leave. So if in the first half it reaches, I am here. But suppose it doesn't reach, then I come.
Automatically it will go to 2.
No, but if the other matters are sometimes some other matters are
okay, that will say.
Yes.
This two letters was listed in the month of June 2022. Where they also this two letters
Yeah.
Maybe the Senate mentioned the listing next to project. Mention the project.
Next week. 24th.
Right.
Yeah.
Mention the pending application.
First March.
Item 1 and 2 of daily list.
Yeah. Ideally, my inspection is that they allowed them to resume classes from 13. And I'm grateful to the solicitor his efforts and Mr. Architect. Because of his efforts, the authors have been finding they've been allowed to resume classes.
Mr. Ege General Counsel for Petitioner submits that the respondents have complied with the
They have allowed us to resume studies from 13.
have allowed the petitioners to resume classes from 13th of February 2023, and therefore he has instructions not to press the present content. Correct? MS A. Gayan and CGC appears on behalf of the respondents. Contempt petition is accordingly closed. Both
Same order.
both separate orders. Yeah.
Petitioner was an against headmaster. At the time of amalgamation, he is redesignated as assistant teacher instead of assistant headmaster. But at the time of amalgamation in the high school, he should be redesignated as assistant headmaster. At page 28, my lord.
Yeah.
Page 28, serial number 13 is the petitioner hearing. Samsul Uddar. He was promoted as headmaster, not in charge before amalgamation. Then he is designated as a class assistant teacher, but he should be at serial number 12. Headmaster, which is again now at the last assistant headmaster. Page 31 kindly pilot page for a moment. Page 31, which is the OM pilot. 7 pilot. Paragraph number 7. Clause 7. Even the highest level school is a high school. The headmaster of high school shall continue after MA. Here, my lord, the post of headmaster of MA school shall be redesignated as assistant headmaster with the same pay scale. Whatever they are drawing as headmaster of MA school, and the post shall be held by existing headmaster of MA school, even if it is not fulfilled the required qualification of the post of assistant headmaster. Before amalgamation, my lord, petitioner has been promoted to the post of headmaster. Then after amalgamation, he should be the assistant headmaster for this job, but he is designated as assistant teacher, and his pay scale also deducted from the assistant headmaster to.
You are from the ME school.
ME school. I was the ME school headmaster before amalgamation. Promotion order at page, my lord, 19, my lord, page number 19. The promotion order.
Yes.
My lord, my grade pay of rupees is 8,700 at the time of promotion. In the fourth line, my lord, I am promoted as headmaster and my grade pay is 8,700. At the time of amalgamation, my lord, my grade pay also deducted to 6,200.
Where is
From
that?
8,000. My base, my lord, 28. My lord, his payroll, serial number 13. Pay scale, my lord, at column number 4, my lord, 14,000 and to 49,000 plus grade pay rupees 6,200. Earlier it was mine at 3,700. But as per the OM, my lord, what I have read it, my pay scale should be same and I should be promoted to the assistant. That is my case, my lord. But although I am asking for my lord to grade pay of rupees 9,000 as per the recent notification was passed by the my lord director of secondary education, but I am not qualified for that grade pay, my lord. 9,400, my lord. Therefore, still state, my lord.
In this OM of 2021,
Yes, my lord.
close 19,
My lord. Clause 7, my lord.
19. Para 19.
Yes, my lord.
What does it say?
Director concerned will issue necessary order for amalgamation for any dispute arising out of the order. The aggrieved institution of public may appeal before the government.
Oh,
in the secondary-
this is only amalgamation,
Yes, ma'am.
only for. But this one is a different issue. Yeah, Majumdar, what is
The answer is page 28.
2020?
Page 28, madam, the cause of correction is shown. Samsung Duda assistant teacher promoted as headmaster at Sudha Valimara, Samsung ME School as per Director of Elementary Education, Assam order number 2017, which the school already amalgamated with Sudha, so copy enclosed. But the designation of Samsung Duda mentioned as AT instead of assistant headmaster in the amalgamation order. Because the promoted order issued after submission of proposal for amalgamation to the inspectors was Kamru. So at the time of amalgamation, he stood as a teacher, assistant teacher. He was not the headmaster. At the time of amalgamation, he remained a teacher. So he would have been designated as the assistant headmaster and at the time of his amalgamation, he was a head teacher of the MSU. Roshi will find, but the designation of Samsung Duda mentioned as AT because promotion order was issued after submission of proposal. So the proposal when he was still an assistant teacher. Now the issue to be seen is whether his
So when
promotion came was-
when the proposal went,
whether promotion came-
he was still a teacher,
Yeah, that is what I was trying to just.
and the promotion order came after the proposal was submitted.
Proposal was submitted.
That is why this issue has.
So therefore, when we issued the amalgamation order, we considered him an assistant teacher and we kept him at that scale. But if he was on the date of amalgamation, if he had become the headmaster, then he is entitled to be the assistant headmaster of the. So for the date of amalgamation,
Amalgamation order 1 January 2018.
and
I promotion is, my lord, to second line of 2017. My lord, before.
so at the date on the date of amalgamation, he remains the headmaster of the school, of the ME school. Therefore, with this correction, it's not because of the fault of the department or because of his fault, because the proposal went thereafter he can be.
Then you can make
It
some.
can be corrected, yes. It can be corrected. Can you send that to the director, Miller? Consider the dates. And as on from the date that he is entitled to.
But Mr.
Yes, Director.
Hazarikal and the counsel for the petitioner. Also heard Mr. R. Majumdar, the standing counsel, secondary education,
Department of Education. Now it's
Department of School Education. Four respondents, 1, 3, 4, 1, 3, and 4.
Yes, sir.
Headmaster and Mr. Chalial and the standing counsel finance for respondent. The petitioner was promoted to the post of headmaster of ME school. Which school? Of
Sola, Boroli, Para,
80
890.
of 80 Sola. I can't make all this.
Sola, Boroli, Para, Ansuli, ME School.
ME school. in the scale pay of rupees 14,000 to rupees 49,000, including grade pay of rupees 8,700 by an order dated 2nd August 2017, by which issued by the Director, Elementary Education. Stop. Thereafter, the school of the petitioner was amalgamated with what school?
My lord, page 20, my lord, Sora, Golden Mala, and ME school, my lord.
Where is this?
Page 20, my lord.
Was amalgamated with Sola Bari Lamara
Ansolik High School, my lord.
Angelic High School
Yes, my lord. Amalgamated of high school.
by an order dated 1st January 2018. At the time of amalgamation, in the said order, the petitioner is shown
Serial number 30.
you are shown as you are amalgamated. No, you
Yes,
are
my lord. The serial number 30. Amalgamated.
amalgamated as an assistant teacher.
Yes, sir. Redesignated, my lord.
Was but in the said amalgamation order, the petitioner was redesignated as assistant teacher in the scale pay of rupees 14,900 dash 49,000 plus grade pay of rupees 6,200. Petitioner, para. It is the case of the petitioner that when the school of the petitioner was amalgamated with the Sola Bari Lamara Anchalik High School, he was serving as a teacher, a headmaster,
Headmaster in charge.
headmaster, not in charge. He was serving as a headmaster of 80 Sola Balimara Anchalik ME School. And in terms of the office memorandum, dated 3rd August 2021, particularly clause 7 within brackets Roman 7, the post of headmaster of any school shall be redesignated as assistant teacher, assistant headmaster, with the same pay scale, whatever they are doing as headmaster of any school. And the post shall be held by the existing headmaster of the ME school, even if he is not fulfilling the required qualifications for the post of assistant headmaster. However, by the said amalgamation order dated 1st January 2018, petitioner has been designated only as assistant teacher instead of headmaster, assistant headmaster, being aggrieved with the amalgamation order dated 3rd January 2018. Petitioner is before this court by way of President. Mr. R. Majumdar and the Standing Council, School Education Department submits that when the proposal was submitted for amalgamation of the petitioner school with the Sola, you know, no? Anchalik High School, he was serving only as a teacher, and therefore, in the said amalgamation order, the petitioner has been redesignated as assistant teacher. Stop. He however fairly submits that when the amalgamation order was issued on 1st January 2018, petitioner was already serving as headmaster of the said ME school in on the strength of the order dated 2nd August 2000. He therefore submits that the anomaly in the amalgamation order dated 1st January 2018 can be rectified by the Director of School Education Department if the same is remanded back to the So, considering the submission made by the Learners Standing Council, School Education Department, this matter is remanded back to the Director of School Education Department. Public responder number 3. It is secondary education only.
The directors are secondary education in the elementary education, but the department as a whole is a department of school education. The secretariat is the department of school education.
Okay,
They have different directors.
okay. If the matter is remanded back to the Director, Secretary Education. Considering the submission made, this matter is remanded back to the Secretary Education Department, Director Secretary Education Department, to consider the grievance of the petitioner, particularly taking the view that before the amalgamation order dated 1st January 2018 was issued, petitioner was already serving as headmaster of the said MS school on the strength of the order dated 2nd August 2017. Stop. The fact that the petitioner was redesignated only as an assistant teacher by the order dated 1st January 2018 was due to the reason that the proposal for amalgamation of the said MS school with so-and-so high school was already sent before the promotion order of the petitioner was issued. So, the respondent number 3 shall consider the case of the petition and thereafter pass appropriate orders rectifying the anomalies in the order dated 1st January 2018. Within the period of 2 months, within the period of 2 months from the date of receipt of the copy of the order.
Regarding the receipt, we consider from the paper for the permission of the headmaster, 8,700.
All this will come, I think. All this will come with the proceed of the
Page 20, madam,
with
the
petition.
amalgamation order was issued by the commissioner and secretary. So then the matter go back to the secretary. Directly was only the amalgamation order may come from the secretary. The director is not in the position to modify it. That's for the number 1.
Okay. Remanded back to the response number 1, public the secretary, school education department. Change.
Or
Yes.
On the death of the father of the petitioner, he was holding the post of assistant teacher in a school. Petitioner applied on time, accordingly his documents are failed before the district level committee. So we kindly have a look at page 27 in the next slide, finals of the meeting, and the concerned page is on page 36. Page 36, serial number 23, last one.
Page.
Page 36. 36.
Serial number.
Serial number 23. My name is last. The ground of rejection has been shown to be rejected as mother and father. My mother is also no longer. My mother was then employed, but the office memorandum, first 15 of the office memorandum, never says if some of the family members is employed, the case of any incumbent cannot be considered. One time considered is must.
Serial number 23, is it?
Yes, serial number 23. In the remarks column, it has been shown that rejected as mother and father. The extreme right.
Oh,
Yes.
okay.
But one time consideration is necessary. In fact, now his mother is also no more. I have annexed the death certificate of mother also.
Where is that?
That is minute, section 9 minute, page 47. Prima facie. That's it. Mother.
When did she?
She died on minute 2/7/2021. That's it. That's the minute I'm trying for a lotion. At least minute, the district minute 20 minute make us there again minute. This is the one.
Yes.
One time consideration is necessary.
After lots of delays, television might after lots of delays.
I have obtained minute this.
This was rejected on 2012. 23/4/2012, DSC minus.
Submitting minute.
And at that time, lots of his financial condition is not lots of work. Just because his mother was lots of working.
I have annexed the minute income certificate also.
So it
Now,
was-
how do you explain the delay?
Yes, minute. I have explained minute. And this minutes minute, I have obtained minute very recently.
From where?
Very recently, some 2 months ago.
From where?
This minute,
How did you obtain? How did you obtain it?
I told before the minute distribution committee and did something, maybe that request minute. It was minute given to me very recently.
Mm.
This is beyond my control. minute.
Where have you?
Where?
Where have you stated explaining your delay?
There are 6 minutes, page 7 minutes.
From where he has,
Just a minute. There are 6 of the page 7. And the petitioner begs to state that the petitioner is not aware of any information as to why his case was not selected by the petitioner. And although he wanted to get the list of minors of DLC, meeting prior to 2021 and thereafter, but he was communicated with the minors of the DLC meeting held there where his case was purportedly shown to be not selected as mother employee. The petitioner was humbly begs to state that his case was not considered and was selected and forwarded by the district committee and thereafter not forwarded to the state level committee at least for one time. Consideration.
When was this communication made to you?
There are 9 page 9.
Where?
There are 9 minutes. The petitioner will text us as page 9. After the said communication, the respondent authorities did nothing, nor informed the petitioner about his fate regarding appointment and compassionate grounds. Thereafter, finding no other alternative, the petitioner approached the opposite party respondent from time to time, praying for her appointment and compassionate grounds, but no result came there. Thus, the petitioner alumni is all members for taking their rights with great economic hardship. It is vegetable expectation that someday he will be given appointment and compassionate grounds. But this, at this stage, the petitioner could realize that the respondent and misguiding him, and finally, he came to know after getting the minutes in the meeting. In this case,
When did you receive the minutes? The date?
the date has not been given.
That's what I want to.
Recently,
Recently means when?
this is beyond my control.
You file an additional affidavit explaining your delay in detail. Mr. Z. Ahmad, then the counsel for petition shall file an additional affidavit explaining the delay in approaching this court. Stop. List the matter after
After 2 weeks.
2 weeks.
Date may kindly be given.
You filed after that, you can mention.
I think that the next week will happen. First week, I think we'll take.
List the matter again on today is 16. 9th. 9th, so March, not 9th.
5.
Kindly take the last order.
Yes.
We are getting instruction whether these are connected to the BSc. Putting him under case suspension after the order dated 38/2022. Page 24. I'm sorry, madam. I'm sorry. It's page 20, page 19. On page 19, first December suspension 30. Same day.
Madam, it was earlier remand and withdraw subsequent decision. My friend has worked the earlier one.
What I have seen is at page. Yes, at page 22 was his first suspension. Then when he was reinstated after the same course, that was she was fine. At page 30.
27.
Page 27 it was reinstated. Page 30 it was regularized. It was regularized. Now we're at page 31. Page 31, the director or secretary division again says, until further order, instructors will serve allowed to group charge of the reconstruction so allowing financial for a dispersed salary. In addition to his normal duty under coordinates, files this existing headmaster, Jahanti Sheikh, has been placed under suspension.
Has he been placed under
Madam,
suspension?
that is the information I have not been able to get as of now. If Lordship decides to respond this matter, demanded that the director of secretary will be only one. After the suspension was revoked by page 27, if there is no other suspension order again, they will revisit this order. Correct? If we keep it waiting for instruction for a related matter, then this matter does not lead anywhere. Disposal, then they will do it within a period of 2 weeks.
Till then, must be plenty order available. Till then, improved order available.
We do not know whether he is under suspension or not.
No,
A period of 2 weeks, then we'll file a replication.
till then, must be improved order available.
You just take instructions, Mr. R. Majumdar, the Standing Council, School Education Department.
Department of School. Secondary education.
Standing Council, Secondary Education. Shall receive instructions. Shall receive instructions as to whether the place petitioner has been again suspended. Stop. How much time will it? Place the matter 24th. After 1 week.
I am holding, still holding the SARS of
We'll see. We'll see.
Till the 15th last week, I can put it in maintenance.
It's not a January.
16 of supplementary link was done.
So before maybe the president of the SLC matter.
Hmm?
The committee was constituted in 13 seats over the 18 members. They are promoted as per rule 13, and the period of the committee is for 3 years. If not new committee is constituted, then it will also be continued till new president or member take over the chair. Accordingly, whether your lawful find access 13 members. But district unity education officer by order dated 9/1/2023, allowed the interactive smooth functioning of the school and other ongoing developmental work as a CPC. The school management committee of the facility of LP school, which was nothing for earlier by the local and same was approved by the due volume number also dated also is there will allow to function till new SMC is requested. Accordingly, it is not functioning manner. There are the one very surprisingly manner on 6 only after 20 days, 27 days, 6 days complete. 6 to 2023. The post about presidency of competition has been put by the Jimpo Nada. Without any notification of any hearing, without any inquiry. While as per rule 35(2), if the post of president is removed, then there might be a resolution by 2/3 majority or proper inquiry based on complaint. Nothing has been happened here. No inquiry, no notice, no opportunity has been given to the patient.
Yes, Sharma.
In the meantime,
You want notice to go, you want instructions first?
I will issue notice, not notice, or I will after instruction.
Okay, third, Mr. B. Raman and the Council for Petition. Mr. Ben Sharma, the understanding council elementary education shall receive instructions. List the matter after first March.
That's an extra copy.
This matter- That was extra copies.
I will after instruction.
in the meantime,
Interim will be considered on the next week.
17, they were getting application.
Another patient to consider this matter will also not heavy. My lord, if I may just give a background. It pertains to, my lord, the right institutions, right colleges. And we both are working. He is working as a senior lecturer, and I am working in the next higher post of principal. I was working in a different institution, and he is working in a different institution. Now, what government has asked him that he was holding the charge of the post of principal in that institution. I was transferred from my present institution to that institution, and I will take over charges from him. So the post is otherwise vacant. Now he puts that to challenge me. And that was big. Basic contention 2. 1, that the order of my transfer is by way of a recommendation of an MLA. So that's initiated. 2, that the post that he is holding on in such basis can only be filled up by promotion and cannot be filled up by transfer in terms of the rules. These are basically one of the 2 contentions that he has faced. Now the imputed order, my lord, would find in the repetition at page 128.
My lord is there in the IAS, main repetition. Last main repetition was supposed to be disposed. And in that case, my lord, there is an order from management appearing on behalf of the elementary education diet.
I am only on the IA, my lord. My lord will consider the
My lord has said that we will decide the main issue on the last occasion. That's why I'm submitting on the strength of that submission. My lord, will you note the order, my lord, was passed on the last occasion.
Which order?
My lord, the order passed in the main repetition. There is an order for the asking for instruction from the diet and from the.
Anyway, let us see what
After my
Maya.
submissions, my lord requires some instruction, my lord will give it. My lord, this is the order at page 120.
Of the writ petition or
Repetition. It's there in the IA also, but I'm showing from the repetition the purpose.
yes.
My lord, the second order. Number so and so 88. In the interest of public service, Abdul Noor Burmian, that is my client, my lord. Principal of Diet Kachar Udarbond is hereby transferred and posted at Diet Hailakandi in the same capacity against the existing vacant post. Honorable has got it. So this is the impugned order by which I was brought to Diet from Udarbhan to Diet Hailakandi. Now your lordship comes to page 114.
Yes.
114. My lord will note this order. It's of 28th December 2021. In the interest of public service, Mohammed Tajuddin Luster, senior lecturer at Diet, Karimganj, is hereby transferred and subsequently posted as senior lecturer at Diet, Hailakandi, with effect from the date of taking over charge against the vacant post. My lord, he was a senior lecturer in Diet, Karimganj, and he was brought to Hailakandi, the present school. Second part of the order, consequent upon joining so-and-so Hailakandi along with financial power under first so-and-so, that order is not clear. My lord will have to just come to page 116. That order, my lord, typing is wrong. My lord. Consequent upon joining of Mother Tajuddin as senior lecturer, he is temporarily allowed to hold the current charge of in-charge principal Diet Hailakandi along with financial powers under provisions of FR 49C of FRSR and as per Finance Department so without statutory power, with effect from the date of taking over charge until further order, or till full-fledged principal is posted, whichever is earlier in addition to it. So he was allowed to hold the current charge. Then I was transferred in the next year to that school, which he is having a advance and he has come. Now, if your lordship comes to page 30 of the petition, his case number before your lordship, page 30.
Yes.
Follow the second paragraph. In view of the above provisions of law, it is mandate of law that the post of principal in Diet College can only be filled up by promotion. However, under Rule 12, an exception has been provided that the government may, for good and sufficient reason, fill up the post of principal for specialized investigation, design, research work, temporarily or on tenure by transfer, deputation from outside the service, if it is satisfied that there is no suitable officer available for the vacancy. From perusal of the impugned transfer order, it appears that the vacant post of principal in Hailakandi Diet College has been filled up permanently by way of transfer, showing the cause of transfer in public interest. The said transfer order therefore cannot be construed that the same was issued under the provisions as aforesaid under Rule 12. Under the same pretext, the petitioner respectfully begs to state that the impugned order of transfer so and so is hereby liable to be set aside and short. He says, my lord, that as I have understood, that the post is to be filled up by promotion. So you cannot fill the post by way of transfer. And by doing that, you have violated the rules. That's the short and simple case of my friend, and the other things come. My initial case is, he has got no right to challenge that order because he has got no right on that post. Now, I'll have to satisfy your lordship that by filling up of that post, his promotional avenue has been lost. I'll have to satisfy my lord that by filling up of that post, his promotional avenue has been lost. My lord, there is a set of rules. These are known as the Assam District Institute Education and Training Diet Rules, Service Rules 2010. Lordship comes to Rule 5, Rule 5 at the next page, or Rule 3, madam. The service shall consist of the following classes and cadres. Class 1 shall include the cadre of principal, vice principal, senior lecturer, and lecturer. Then, my lord, 4. The strength of the class 1 cadre of the service shall be as determined by the government from time to time. The strength of the cadre of the service on the date of commencement of this group shall be as shown in schedule 1. My lord comes to schedule 1.
Where's the single?
My lord, just maybe, my lord, 2-3 pages from the backside, my lord. 4-5 pages from the backside. It will be 2809, my lord. Page number 2809 of the cadre. Top portion, my lord, number 2809, my lord. On the right hand side, top, my lord, we get the number.
I don't have 2809.
Immediately after the rule 29, that is repeal and saving in act.
I have only up to rule 18.
My lord will have this. Hey, last one.
Rule 29.
The rule starts at page, my lord, 2009, and my lord will come to 2808. Sorry, 2801 it starts. My lord will come to 2809.
Yeah.
Oh, my lord has got it. My lord will see principal. Total number of posts 18. Vice principal is a cadre 13. Senior lecturer is a cadre 100. And this is a cadre for the whole of the state. There is only one duration list for all the incumbents in a particular cadre. Now, my lord will come to rule 5. My lord will have principal. The post of principal shall be filled up by promotion from amongst the select list of vice principal, senior or senior lecturer, having not less than 10 years as experience as lecturer, senior lecturer or vice principal. So there is a selection amongst the 3 feeder cadres, and then the promotion is made. Now, my lord will come to vice principal, senior lecturer. The post of vice principal, senior lecturer, which my friend is holding now, my lord, shall be filled up by promotion from the select list of lecturers in the district resource unit, so and so, so and so, so and so, so and so, so and so. My lord, then they say pre-service training is from select list of lecturers. My lord got it? From the select list of lecturers. Now, my lord, there is no difference between the promotion made to the post of principal. It is from the feeder cadre of senior lecturer, vice principal. And similarly, my lord, for senior lecturer, it's from the post of lecturer. Now, the question that the argument that my friend has developed, if I may just submit, just for testing that, he says that a vacant post in a particular school or a college like institution cannot be filled up by transfer from another institution. If that is correct, then a post of senior lecturer in a particular institution can also not be filled up from transfer from another institution, because both 5.1 and 5.2 are same. You cannot. My lord will come to 114 just for a second again. 114 or 116. That's better. Please, 116. The order which I just placed for my lord. My lord will see, in the interest of public service, Mohammed Tajuddin of the senior lecturer type Karimganj is hereby transferred and subsequently posted as senior lecturer type Hailakandi, with effect from the date of taking over charge of the post against the targeted. But if he cannot be brought, if he is challenging this transfer, he is very coming to the call. The school is also not permissible under the rules, and any act done which is in violation of the rules is void. But my lord, a post is in a cadre. It may figure in any institution. Now, my lord will see, if the post in Hailakandi has been filled up, the post in Udarpand is vacant. So, when the recruitment takes place, my lord, there will be a vacancy always. It is not that my friends' clients' promotional chances are being done away. So, my lord, this plea that my friend is taking is self-defeating. Because he himself, under the very same rules, came on transferring 2001 to the present institution. And my lord, with regard to that MLA's influence, my lord, if a person otherwise agreed would have come up before your lordship, my lord would have examined that issue. And this honorable court has also said that merely because the MLA has recommended, that will not be fatal until and unless there is something more. You will have to bring that something more, you will have to add it as a party, allege malafide, and thereafter proceed. Nothing is here. My lord, the question here is, he has got no right. He'll have to show his right to assail this order before the lordship. My lord, he is not a person aggrieved. Merely by holding a charge, and that too for a temporary basis, if it is filled up on a regular basis by someone, if he was not qualified, maybe there would have been a count. But I am a regular principal, promoted regular principal. I was promoted way back 25 to 2021. I want to just think about that. 25 to 2021. It's followed in page 43 of the IAP. My lord, I am at the serial number next page, my lord, page 44, serial number 30. Now, my lord would find at page 39, and it's A4.
Same IA,
Same.
34.
39, sorry. This is the gradation list of, my lord, senior lecturers. And there is only one gradation for all over the state. They are posted at different places. Would find, my lord, find at the right hand side. They are posted in different institutions. One gradation. Then the promotional thing. So, my lord, it's a state cadre. One cadre, my lord, for all over the state. In that view of the matter, a person being figuring college A or college B will not make any difference. Because he may not be even promoted. His only thing is that there has to be a vacancy. There is a vacancy. The vacancy has never been filled up. And I am approaching my age of superannuation October. And this is my hometown. Government may have decided, but that is the issue by not wearing. Say, my lord, I have been transferred visa regular bills. He comes up before your lordship and makes a challenge. Then my lord may like to go into that aspect. But here, the very person who is challenging does not have a right to that post. And lordship, one judgment which on the last occasion, my lord, I wanted to place before my lord. Only on the point that if a post is created in a cadre at a particular place, that place has to be in the promotion. It's also a rule wherein said that post will be filled up by promotion. That only post has to be filled up by promotion. It cannot be filled up by transfer. Supreme Court said it's not correct. Para 12 at page 38. Incidentally, it would be incongruous to hold that when a post is created in a certain grade, category or cadre, and it is to be filled in, someone who is already in that grade, category or cadre cannot be transferred to that post, and the post so vacated by it can be filled in the manner prescribed. Even if there was some subject, though there is none, in the contention on behalf of the appellant that whenever unspecified specialist post is converted into a specific post, it can only be filled up by promotion, yet when someone who is already in that grade is transferred to the newly created post and the post vacated by such transferred employee is offered by way of promotion, which in fact was done in this case, there is any violation of the rules. As pointed out earlier, when a post is created, it is an addition to the strength of that particular category. And the additional strength has to be filled up in the manner prescribed in the rule, and no sanctity attaches to the place where the post is created, but the sanctity attaches to the number of posts and the manner of filling them up. Now, Dr. B.S. Jain was already holding the post in Supertime Grade 2 at Shimla, when a post in Supertime Grade 2 in ophthalmology was created at Whittington Hospital from amongst the unspecified specialist posts. Even if this additional post has to be filled in by promotion as contended by the appellant, it is not open to him to urge that the post at Whittington Hospital alone must have been filled in by promotion. Dr. B.S. Jain was transferred to the post created at Whittington Hospital, and the post vacated by him, which is in Supertime Grade 2, was open to the appellant as and by way of promotion. Therefore, even if the contention of the appellant is to be accepted, there is no violation of Rule 8.3. Equally, it is also not correct to contend that Dr. B.S. Jain could not have been transferred to the post created at Whittington Hospital. Transfers in posts which are in same grade or are considered equivalent can be effected on administrative exigencies. Once a new post is created and it is an increase in the cadre strength of the cadre in which the post is created, everyone in that cadre is eligible to that, fill in that post, and transfer is permissible. Transfer of so and so is therefore beyond jurisdiction, beyond question. In E.P. Royappa versus so and so, because it is observed that services of cadre officers are utilized in different posts of equal status and responsibility because of exigencies of administration and employing the best available talent in the suitable post. There is no hostile discrimination in transfer from one post to another when the posts are of equal status and responsibility. Therefore, it is futile to urge that while filling in the post created at Whittington in Supertime Grade 2 by transfer of so and so, a person already promoted to so and so was invalid in as much as the post was not filled in by promotion or direct recruitment but by transfer. So, my lord, the very contention that my friend is trying to raise with you, leaving aside, my lord, the issue that he is not even, my lord, a person agree, that issue that he is trying to reveal is not sustainable on two counts. One, my lord, it's a state cadre, I can be transferred. Two, you, by way of the same rules, while the post of senior lecturer was transferred from one school, which is again a promotion, you could not have been done. So for you, when it is done, it is correct. For when others it is done, it is wrong, illegal. Three, my lord, this proposition that has been laid down in paragraph 12 of this case. This is the humble submission. Yes. Now, my lord, what happened? There was an interim order. I did not place the name on it. I'm sorry. There is an interim order dated 6/1/2023. I am, my lord, at page 29. My lord, the relevant would be para 4, my lord, at page 31. His submission. As per the provision of Rule 5 of the said 2010 Rule Service Rule, the post of principal diet is to be filled up by promotion from the select list of vice principal, senior lecturer, having not less than 10 years of experience as lecturer, senior lecturer, or vice principal. Then, my lord, after the factual matrices, my lord would see para 9. The petitioner had been agreed with such transfer of the respondent number 6 as a regular principal type, has preferred this petition stating that the post of principal as provided under the statutory rules of 2010 can be filled up by way of promotion only, and the existing vacant post of principal type cannot be filled up by transfer. Then, my lord, pursuant to the court order, the respondent state government in the Department of School Education through the learned council of the state said department placed the relevant written information on so and so in the matter, which goes to show that so and so submitted an application before director so and so for a transfer from Diet Demaji to Diet Lakshmi due to a family person problem against the vacant post due to transfer of the regular principal of so and so. Similarly, with regard to respondent number 6, it is seen that the MLA of Kachar recommended the transfer of respondent number 6 principal Diet Kachar to Diet Hailakandi against the existing vacant post, requesting the authority concerned to allow one Jivendra Sai Datta, a senior lecturer of Diet Kachar, to hold the current charge of principal Diet Kachar in place of respondent number 6. Then, my lord, would see para 14. 12 months. These requests were forwarded to to the authorities in the Department of School Education of State by the Director of SCRT Assam, and matters were accordingly placed before the authority concerned. Since the regular principals of diet at Kachar and Tamar did not complete 2 years of their continuous service in their respective diet, the matter was placed before the concerned minister for necessary approval. Accordingly, the departmental minister concerned approved such transfer, however, with the observation that both the transfers may be approved in public interest, though in the case of so and so, it was a request, and in case of respond number 6, it was the request of the MLA Kachar for his transfer to diet Hailakandi with a specific request that one so and so should be allowed to hold the charge of in-charge principal at diet. Accordingly, by the improved notification number so and so, Srimati Dunami Hernas, principal of so and so, has been transferred and posted at diet Lakhimpur in the same capacity against the existing vacant post in interest of public service. Similarly, by order dated so and so, State Government and the Department of School Education transferred the respond number 6 from principal so and so and posted it at diet Hailakandi in the same capacity against the existing vacant post in the interest of public service, allowing so and so to take over charge of in-charge principal diet from respond number 6. The petitioner submitted that the transfer of respond number 6 is not only in violation of Rule 2010 rules, but also only to accommodate the said respondent and Dr. Jivendra Datta so and so, that to the personal interest of the MLA Kachar, and therefore such transfer is arbitrary in nature. Then, my lord, there are 21. As such, the impugned order of transfer of respond number 6 as principal so and so in terms of so and so issued by the government in the so and so shall remain suspended until further order. But it was not placed before my honorable court about the actual purport of the 2010 rules. Actual factual matrix existing in the case involving the petitioner himself, when he was also transferred from one school to the other, and accordingly this order came. My humble submission, my lord, the impugned order requires to be vacated, and my lord, the position therein requires to be restored. My lord, after passing of this order, this impugned, the government, my lord, issued an order to me, asking me to go back in view of this order to that school. But that is, my lord, again an interim arrangement. Moment this order gets vacated or the repetition goes, my lord, that will neither be a new cause of action for me or nothing. It's just a continuation, compliance of the orders passed by this one, which is interim. This is not.
Mr. Nair,
Lordship.
if I vacate this interim order,
Lordship.
the whole basis of the petition goes.
Naturally, if it goes, my lord, it goes, because he otherwise will have no right. Because my lord, he'll have no right. Because continuation of this interim order will also, my lord, not be in accordance with law.
No, that's correct.
Lordship.
It will be like disposing of the writ.
My lord, we'll take up the writ petition, my lord, if required for disposal, along with this, my lord.
Yes.
If it goes on that, because in the writ petition, other than these points, there is nothing.
Nothing in it.
Nothing.
So basically, only
The
thing is
disposal of the IA would also tantamount to disposal of the writ petition.
correct.
Not that much only.
So your respondent 6.
I'm responding.
How about the school education?
They will have, the question of law is involved here, but factual matrices may not come in. Until and unless my lord is not satisfied with the law point. If my lord is satisfied with the law point, that's the end of the my humble submission, subject to what.
No, filing of affidavit is a different thing. Here, see, respondent number 6 is retiring. Petitioner is having an interim order in his pocket. All right. And if IA is considered, writ petitioner automatically goes. So you just take instruction on the factual point of this,
It's already recorded.
particularly the rules.
My lord, the records, how the transfer was effected, that is there in the interim order record.
Yeah, that is.
That is.
So if you are willing, we can take up the issue today. Sir. Now, if it is some other day, it has to be a short date.
Well, let me be.
Buyan?
Because my lord, he is suffering, my lord, the man is
There
suffering.
is no suffering.
No, how can you say that?
In the submission, I have not interpreted. This is a clear case of missing and the policy can power for effecting the transfer of the respondent number 6. I will try my level best to satisfy my lordship that how political people, has stressed the rule. There is no value for this political people, the rule and the court of law. Even after the passing of the interim order, this man, respondent number 6, with his wounds and other person goes to the court and break down the law and take over the charge. Thus, see the attitude of this respondent number 6. And the manner in which the case is projected, is absolutely not correct. I will satisfy, there is an affidavit is why required, from my limited understanding, I am respectfully back to submit, is that the rule, whether the post of the principal is a single cadre post or in the entire state cadre post, that instruction is required. My saying or my respected senior state saying will not suffice because it will be the stand of the government, that is required. Secondly, that whether even if the rules, I say, even it is within the complete or power of the rule, this transfer order has been effected. Whether there are lots of judgments in there, under such political influence, this transfer order can be constituted to be an arbitrary in nature. That's why, this honorable court, while all for the record, going through the law, was surprised, that in that manner, this, transfer order was effected. Yes, those records are already, as a part of the record have been made, The record was called for.
Records are there?
Short affidavit can be filed, within next week,
Can you file your affidavit within 1 week time?
Why?
Let them produce their records for your lordship.
Records are there, records will be sufficient.
Records are there, madam, in the court, I suppose.
Records are here.
Here, madam.
Records are there, what kind of tools?
Records are there, madam. Records are still, sir.
Earlier it was called for, but I think return back or something like that.
You must have taken back the records.
Sir, Mr. Big question is here on the last page.
Can you file your affidavit?
Madam,
within 1
it is
week?
kept as a part of record. The relevant instructions placed before this court today by the Department of School Education Assam through its learned council is kept as part of the record.
Instructions.
Instructions, madam, let know those materials.
What is the file, file is required.
Madam, let my friend, madam, will grant this prayer, madam, I have no issues, madam. But madam, let my friend satisfy your logic. His personal right that has been. Let him, madam, we hear on that and then come to a conclusion.
Because my learned senior friend, I stand on the same.
Today itself, madam, let him satisfy your logic that this is his right that has been violated. I'll be obliged. The special commissioner.
When can you file your affidavit? No, don't make it too.
On 2 occasions, madam, this matter was taken, nothing.
When was this filed?
Madam, it was filed long back, 31, 2023. So 15 days, that 2263 is also taken. No, we have filed, no, we have filed 71. 2263 has automatically kicked. I'm not pressing on that, but 2263 has kicked.
Did you file it under 226?
Yes, ma'am, 2263.
Thereafter order has been passed, then the time has been given to file the or reply.
Madam, page 2. Interim order was never extended.
I've seen.
But I'm not on that. I want to say.
Mr. Sharma, give a date. We can hear it and discuss it.
Next
Madam,
time,
may I- may I make one submission? Madam, may allow them to file their affidavit. But let my friend satisfy your lordship of his right that has been violated. My lord will have to hear on that.
My senior man want to bulldoze me to the extent.
Naturally, not talking about bulldozing.
I
2263 has kicked in, but I'm not
I
pressing.
have a right, this honorable court has gone from my right and then passing it to order.
That was a one-sided hearing, my lord.
I am not.
These facts were not placed. Unlisted, it was moved and that was done, my lord.
You take on her, you can add the counsel for the applicant. The senior counsel assisted by Mr.
HK does.
HK does for the applicant, also have Mr. We are for counsel for the lead petitioner, opposite party number 1.
We are opposite to
One.
one. Page 3 is there.
As well as Mr. B.N. Sharma, the standing counsel. Elementary education. Elementary education. After hearing parties, I am of the considered view that instead of considering the present right, main petition should be disposed of at an early date. Accordingly, list this IA with the petition on when shall we-
23rd, my lord.
yeah, 23rd, on 23rd for final disposal. In the meantime, the school education department is allowed to file contract.
If there is no, affidavit, my lord, they can produce the record.
Then the standing council. School education department is also directed. School education department directed to produce the records.
My lord, one observation. If the matter cannot be disposed of, my lord will consider my IA. That one.
Okay, if the main petition cannot be disposed of on the next the IA shall be considered. Your respondent number MS.GD Babat, Learned Counsel, Learned Government Advocate, appears for respondent number 6.
The IA.
That is the SCRT.
No, it's a deputy commissioner.
For the
It would
respondent
be
number
respondent number
6. How about respondent number 5 and 4? MS P. Sharma,
my lord, 5, my senior middleman, 4 has got no role
standing counsel,
of public service.
Assam Public Service Commission,
Has got no role.
appears for Assam, Assam Public Service. 4 has no role.
Has got no role. It's internal, man. They only come when the selection is there. So let it be like that. My lord, once a month, oblige.
6 of the list administration.
It's not that's the bottom. What is this?
This matter is an order of transfer by each regular director. And transfer to an outside of and what is the person of addition to director rank. And what is the third matter here? Now, my lord, the issue that required to be determined is that whether this poster had a post or not. Because my lord, the schedule the rules of some education rules shows by lord one poster of DPI. Now the DPI post has been bifurcated into 3 directors. That is in 2005. And the directors are that were completed, and it is the one of the petition is the only director, only regular director. Others are either might have on in-charge basis or might have some additional director has been posted. Now, by the interim order, the petitioner has been shifted from the director of secondary education and posted as director of Boro media and Boro and other languages media. Now, his case was that the interim order was passed on 22nd of September 2021. And at that point of time, there was no post. The director of Boro Media
was not there. It has been, my lord, only subsequently on 27/9/2021. The notification has been issued for the directorate of Boro medium and other medium. And there is a notification which says it should be in the schedule 1 of the rule 4 of the 1982 Assam Education Rules. Now the government has filed affidavit, and the query was whether the Boro medium director is director who is a anchor. In the affidavit, the government has come up saying that it has even the director of higher and secondary and city departments, minor, elementary, they have not been anchored in the schedule. There was no amendment because my rules require that the schedule has to be amended to be anchored. Now the affidavit is one of very cleverly drafted. They do not say whether the director of secondary education was holding earlier and the other two directors which came into being after the bifurcation, whether they are cadre posts or not. At least, I do not find it affidavit specifically saying that these are not cadre posts. So my understanding will be that in the schedule the DPI post is there, but against DPI only one post is so. In 2005, it has been bifurcated and there have been 3 directors. My understanding is that all these 3 directors will be deemed to be the DPI for the purpose of encadrement until the rules are amended. But the fact remains that the notification directing to incorporate the director of Boro medium, that amendment has also not been made.
Let us see that notification.
There are 2 notifications. The notification by which it has been 27/9/2021 that your worship will find it the affidavit in operation filed by the government at 1616. I'm sorry, page 16
Of the affidavit?
of the government's affidavit.
Yes.
Annex B. This is a notification dated 27 September 2021. In continuation of the government notification issued by number such and such dated 22/7/2021 that your worship will find at page 28. Notifying the post of director of Boro medium and other tribal languages in the rank of full-fledged director, the same post of director of Boro medium and other tribal languages is created by number such and such dated 11/9/2022 is hereby entered in Schedule 1 under Rule 4 of the Assam Education Service Rule 1982, subject to amendment of Schedule 1 under Rule 4 of the Assam Education Service Rule 1982. Now, my lord, if your worship comes to the Assam Education Rules, Assam Education Service Rules 1982, your worship will find it at page 698. Rule 3 specifies the class and cadre. Page 699. Rule 3. The service shall consist of the following. Class 1, Director of Public Instruction, then the Additional Director of Public Instruction, etc. Then your worship may come to Schedule 1 at page 712. Seven or two is the schedule. Schedule, my lord, there is a post of DPI total number of posts 1. And the schedule does not include any director. Therefore, if your OSIP comes to rule 3.2, sub-rule 2 of rule 3, your OSIP will find at page 701, sub-rule 2, the service may also include any post equivalent to a post in any of the cadres mentioned in sub-rule 1 and any cadre or post declared by the government to be a cadre of the service. From these rules, it appears that there is only one post of the DPI. Although it has been bifurcated, there is no notification or amendment of the rules. Directors are not included in the schedule. Therefore, the clarification that was sought by the Summary Court was that whether the directorates of higher education, secondary education, and elementary education are indicated in the rank of DPI. So in the affidavit, my lord, they do not clearly say that they are not entitled.
No, rule 3.2. Let us read this again. Service may also include.
Yes, ma'am. Any post equivalent to a post in any of the cadres mentioned in sub-rule 1 and any cadre or post declared by the government to be a cadre of service.
So in terms of rule 3.2, maybe an amendment may not be required.
My understanding would be, my lord, unless the rules are incorporated, the schedule, my lord, is incorporated. One cannot really put the cadre post.
But then this says any cadre or post declared by government to be cadre of the service. It says like this.
Yes, mother, there are two aspects of understanding this matter. That may be one interpretation which also goes in my favor. Because you have issued a notification by which you have bifurcated the DPI. And while you have created the post of director of the tribal languages, that minor notification has come subsequent to my transfer. So if we go by rule sub-rule 2, understanding that no amendment is required, then my lord, I stand in a better position. But if the amendment is to be made to other rules, then my lord, the situation is a little different. Because directors are also not entitled. I claim that I am DPI. Because DPI post is there, but bifurcated. So 3 posts have been created. So I was holding a post of DPI. That will be my submission. But if you also suppose that the amendment is not required, then why not they could not have transferred me to an after post. And subsequently, my lord, in the additional affidavit, I have given one document the other day. Where a notification that is 49 2020 is 91. I have placed it on record. The Governor of Assam, in the interest of public service, is pleased to order the creation of a new directorate, namely Directorate of Guru Medium and other tribal languages, with the following functions and administrative structure, aims and objectives. Then serial number 5, organization and structure. The Directorate of Guru Medium and Mother Tribal Languages will be headed by a director in the rank and position of additional director.
Yeah, this is again one issue. Now, this is, it says it is in the position of additional director. So if you come back again, we was the order. Page 16
Yes, fine.
of your affidavit, of your writ petition. The first 3 lines.
Of the government secretary.
Your writ petition. No. I think it is the government's affidavit.
Yes, government secretary. In continuation of the government notification dated 22/7/2021, notifying the post of director of Guru Medium and other tribal languages in the rank of full-fledged director. That has come on 22/7/2021.
22/7/2021. Where is this?
That is at my lord, page 28 of the regulation. In persons of the conference given by Finance Society Department right here numbers dated number substances dated 27/2016, and in partial modification of the government notification issued on 4/9/2020, Governor of Assam is pleased to notify the postal director of Guru Medium and other tribal languages in the rank of full-fledged director.
So now it has been
Upgraded.
upgraded.
I have annexed this in the writ petition itself, and my case was that although we have upgraded, it has not been entered.
That is the whole issue.
And the encadrement has come, if we take this my lord government certificate at page 16 and Annexure B, it has come on 27 September 2021. After the petition was transferred.
Yes.
So that is the crux of the matter. First, perhaps your worship may decide that whether the directors are entered post or not. And without even deciding that, your worship may take note of this notification, which are the upgradation of the scope for tribal languages that is subsequent to my transfer. So at the time, relevant time when I was transferred, it was in the rank of additional director.
1 minute. Where was your promotion order?
My transfer order is at page 30, 30. That is dated 22nd of September 2021.
So the post of director, tribal language, whatever, Boroland, it was upgraded to a full-fledged director prior to your transfer order.
No.
Yes.
It has been upgraded only
It
after
is updated prior to this transfer. Correct. Worship is correct. It is updated prior to this transfer.
Because this upgradation order is
Right.
22/7/2021,
Yes, yes,
and your transfer order is 22nd September
Yes,
2021.
but then, my lord, that has been notified only by this, my lord, page 16 affidavit order, by which, my lord, it has been entered in schedule 1. That is the order dated 27 September. So, entitlement was subsequent to
my order of transfer.
Therefore, then in that case, the document in your additional affidavit has no consequence in view of the petition or
And the order of
so you cannot be said that you have been demoted. So that aspect is not.
no, my submission would be that you have entered the schedule subsequent to my
Promotion, transfer.
my transfer, and that will have a bearing on deciding whether I was holding the post in the category or not. And because by virtue of that clarification, my submission will be that the three directors in the higher secretary and elementary, they are a part of the DPI.
When was the trifurcation made?
My clarification order was placed by my learned friend, Sir Kopivo, sir. I think there also in the representative, my lord, it will be 16th of August 2005.
Yes.
Definitely dated 18/1/2023. Because the honorable directed that the gather position should be clarified. Then the certificate was filed on 2023. Running date will be my 38th. That is a notification dated 16th August 2005.
Running page 38.
Mother may have provided an act.
That I have the trifurcation. August
16th August 2005.
Yes.
And my submission would be by virtue of this clarification, although the schedule has not been incorporated, the Directorate of Higher Education, Secondary Education, and Residential Education are part of DPA. If that be so, the notification upgrading it, which has been given effect only subsequent to my order of transfer. And I am the only regular director in all the directorates. There is no other regular director. And admittedly, the private respondent is serving in the rank of additional director.
The last occasion, the only reliance that was being placed was upon the fact that it is the post of the director and it was the all other arguments were given. I had made a sufficient yesterday that I go to the verification, I have shown one line there. It is not a resolution. The arguments which were earlier not, which were actually given up, as I understood of that, that's not been clear. Worshiping pending have their election, their petition, worshiping fine. At page 20.
Which
Hmm.
concept of the cabinet in the meeting reference to inside right addition item in the care of the processing server is to regularize the services of resource. At present, holding the charge of Director of Higher Education as Director of Higher Education, the data regularize the services of the program. And at what post the regularization is done, so he was holding the charge of Director of Higher Education. Therefore, worship of the notification of that page 28, 22nd of July, making it the post of full-fledged director.
Yes.
It is not from dispute that the petition was within the post of director, secondary education announcement of members of the director of education. Going by the rules, these are for the first article, these are not entered posts. While holding those posts, there was no objection. In fact, he wants to go back to a post which is still as per not entered. Last week when the government actually was being referred to, what was it? Very cunningly it was considered. Rather than cunning, it can also be some sort of type of wisdom. It was not stated the exact words. There's nothing cunning with the department matter. Just I'll place the instruction check down. And read the instruction for it.
1 minute.
It says, when we were either there is a clear what the department actually had said is this: with reference to the subject cited above, I am directed to say that the post of Director of Elementary Education, Director of Secondary Education, and Director of Higher Education Assam have not been shown entered in the Assam Education Service since 1982 and in the amended PSU school. Department was stable. It is not there. By drafting the effects perhaps how the list those were perhaps got it. There's nothing wrong in having that regulated marks. The department was necessity. That is second part of it. Both the issues kind of them, whether it's an embedded post or not an embedded post. Once he accepts two of those posts, not the position to say that I will not go to an embedded post, this has been answered by the other Supreme Court. The concept person goes, even if he goes out of the campus without anything, there is no requirement of asking me that you check the whether it's like to go to another. It is acceptable. It is a post of the director. It does not lose any of the service benefits. Nothing is lost by it. We have a director. We need a person with. In fact, if it used to be the only regular director, being a new directorate, perhaps the best. That is the wisdom of the Lord. Perhaps that is the best way to start. Any other objection to that if nothing is changed? His position does not go, his salary does not go, his rank does not go, his seniority does not go, he doesn't even need to have it. Nothing has changed. What has changed is you go and get charge of that. And transform as a man of good submission. One incident of service, which if it is not made laughing, if it is not made out of external officials, or if it is not made by a authority which is not competent to me, or if it causes loss to me, particularly income, but also be with a black interfering this. So judgments I can place like this. These were the two basic arguments of the last of the man said, I am showing you the definition itself that there is nothing wrong with it. That is what our affidavit says so. They will not come to it. They have not said that they have accepted the post of director of secondary education or the post of higher education under some compulsion. In fact, it was regularized in the post of director of higher education. That
did not really have any objection to that. Because this, you are regularizing the untethered post, something which I cannot go to. Do not do that. It's very clearly to be a regular action based on an untethered post. My perception is that we cannot be allowed to show what and post at the same time. Polygon untethered post, till it suits him, he stays there happy as a cadet post. That is the end cadet post. It's not an untethered. These contradictions kind of in the reflection itself shows that the only objection is that he has been moved out of one director and making some activities. He doesn't want to do that. He doesn't want to start up a director of the whole million. So therefore, I was interested in no. My definition of virtue is that it was very specific. When we try to say Version 287 para each. The last 5 minutes. Towards the each 7 of my Version is para in the second paragraph. From the bottom, 5th line, last 3 words, by the it starts with the word notification. A notification number AC for the 2006 version 5. By the same notification letter 39,000, the replication of himself also was allowed to go to charge of director of higher education. In addition to his own duties, while he was the joint director in the directorate of secondary education. Therefore, there is no justification that regards of the information that an officer of the rank of additional director cannot hold the charge of director of secondary education because the petitioner himself earlier in the rank of joint director, which is below the rank of director, was holding the charge of director of higher education. So for the mainstream, you must see the mainstream directories. He is happy to hold an anchored post, an unanchored post, get regularized in the post. Everything is happy with it. The moment comes up a new directory. Please go very well. And that is what is not allowed. We need to have the directories. We have because we need to have some evidence. In all that we have seen that there is a letter saying that I need a prior. These are things which will have to be adjusted in the directory system. Not in case that we deny that driver or we deny the power. This will be clear. So they just make the government at the level of the director. It's not in a position where he has to pay before. So it is in a position where you cannot put the government. I cannot put it like this. That's a different aspect. But I will not go there. It's another aspect. The transfer is not one without jurisdiction. The competent authority decision. The transfer order is not one of nullify. There is no such allegation, there is no such private responsibility to show that yes, this man has written nullify case. Nullify cannot be on the part of the government itself. It's no allegation. There is no standard saying which was subtly professed but could not stand that I have been demoted, that there is any loss to any of the service.
Anyway, he's not pressing the demotion part.
The grounds that were taken or could have been taken, none could be taken, and the one that was sought to be taken, had to be done. In my humble submission, nothing wrong with this.
Transfer order, according to you, can be challenged only when it has been passed by an authority.
Authority was not competent to do so.
Not competent to do
Not
so.
competent to do so. Here, that is not the ground of challenge. It can be done if it is malicious, if it is malafide, it can be to harm in some manner. Not the allegation now. That he has lost some service credit. I will not say demotion. Any other service. Nothing. Transfer order itself we might not say. Everything will be. Question that I can never transfer the act page 30. In
the interest of public service, she says, so director of civil education is hereby transferred and posted as director of both Indian and other federal languages with effect from the date of taking over of charge against the existing agency. Does it bring him down? Does it take away any of his service benefits? The only allegation is that I cannot be posted out of my career. You were in a post which, according to your explanation, is not in the career. Previous to that, you were in a post which, according to you, was not in the category. Why not objections there? Objection is when it is a new directive. Therefore, madam, when none of the grounds which have been taken up in law has been taken into consideration, my humble submission does not require interference at this stage. He has a difficulty, of course, whether he will always make an application to the government. That can always be considered. There is no difficulty in that. It is for the appropriate authority to look into who should be posted. One judgment I referred to, this is 2013, 3 SCC 526. Then we are at page 24. Para 24. Before concluding, it is essential to deal with certain inferences drawn by the learned simple judge of the High Court. According to the learned simple judge, prior consent of an employee is imperative, binding, preemptory, and mandatory before he is posted on deputation outside his parent department. No statutory rule has been brought to our notice requiring prior consent of an employee before his deployment against a post beyond his parent career. The mere fact that appellant's consent was not sought for them before their posting to Government Medical College so would not, in our view, have any determinative effect on the present controversy. Broadly, an employee can be posted or transferred to a post against which is selected. This would ensure his stationing within the cadre of posts under his principal employer. His posting may, however, be regulated differently by statutory rules governing his conditions of service. In the absence of any such rules, an employee cannot be posted beyond the cadre to which is selected without his willingness or agency. Therefore, an employee's posting or transfer to a department other than the one he is appointed against his will would be impermissible. But willingness of posting beyond the cadre need not be expressly sought. It can be implied. It need not be in the nature of a written consent. Consent of posting or transfer beyond the cadre is inferable from the conduct of the inquiry who does not protest or contest such a posting and transfer. In each of the earlier occasions, posts which were according to him not in the category, they accepted. There was no reason for the department to find out whether they are happy with it. They have been accepting what is stated. He was regularized in such a post. That is what is stated. Obviously, the next model is 1995, USCC factor, and there are 7. 1995, USCC 532, there are 7.
1995. That one I don't have.
This transfer should be it is needless to emphasize that a government people or any servant of a public member has no legal right to insist on being posted at any particular place. It cannot be disputed with the respondent who is a transferable post, and unless specifically provided in the service conditions, he has no choice in the matter. Para 7.
Yes,
1001 SSC 508, the grounds on which transfer challenge.
5.
2001 SCC 508. I apologize for that, that's another question that this will continue. And para 4, the grounds. An order transfer to enter is a part of the service conditions, and such order transfer is not required to be interfered with lightly by an exercise of its discretionary jurisdiction, unless the court finds that either the order is null or the service will prohibit such transfer, or that the authorities who issued the order had no competence to transfer. So, as this is none of these ones in the present petition. There are certain number of non-decision that I would not like to cover. In a nutshell, madam, grounds on which a transfer will be interfered with have not been taken by the petitioner. His very conduct shows that he was very happy with transfers to non-academic posts in the past. There is no grievance at any point of time. There will be no loss to his service benefits in this transfer. There will be no requirement. There was actually no reason for him to have acquisition of the petition. Does not deserve for that. He has some personal technical difficulties and more than application of the authorities which should be considered. So far as this protection that the particular director was Canada, after he came in, he was recognized as a director. After he was regularly in charge, that recognition is allowed in the therefore the NCADA level is very ground that it is because the NCADA post has been replaced by NCADA only that director. Not the Directorate of Elementary Education or Secondary Education or Higher Education. There is no notification for it. But the Directorate of Foreign and other tribal languages has now been NCADA. So any remarks that he had about keeping a non-CADA post.
what do you say about that language?
So that is what I was trying to say. When he
Where
became
was that in Canada?
in our estimating propositions that given that environment order at page 16.
Page?
16 of my estimating proposition.
Yes.
That is when it was encountered after his transfer to the state post.
Yes. It says subject to amendment of schedule.
Yes, the other posts, the elementary, he buys for the post of director of secondary education. He says, I cannot do the action. There is no notification saying that even the director of secondary education would be NCADA subject to it. There is no such move for the post at all. At least in the post in which the petitioner has been transferred, there is a step by the government to have it NCADA for purposes subject to amendment of the rules. If the amendment by the amendment of the rules is specifically said we don't NCADA this, it's a different issue. Otherwise, the government will stand is best to have it NCADA. Others are not even on that level. He accepted all the other postings when there was no question of any NCADA. Now, once he is posted here, we take care of his grievances. We say that okay, we NCADA. We will not put you at a dilemma.
DPI was the only post entered, we entered this also, subject to amendment. When the amendment comes, the rules will also contain this stuff,
You have stated that DBI has been
trifurcated,
trafficated.
yes, but they have not been entered. The entertainment for them is not coming as of yet. So all the time that he held the post of director, had post of the director of secondary education. Those are not kind of post.
What do you say to Rule 3.2?
Rule. The service may also include any post increment of post of any of the cadres mentioned in Sub-Rule 1. Any cadre proposed declared by the government to be cadre of the service. So now here, there is no encouragement of the director of secondary education, the director of higher education, or the director of education, either the government or by the. That's not. The post to which the petitioner has been transferred comes under 322.
No, actually, how do you interpret 3.2?
Even any post which is equivalent to the post of the cadres mentioned in the sub-rule. The DPI's post is equivalent to the director of secondary education or director of education, and also the director of board education, tribal and languages. In fact, for the Bodo language, government is doing more specific by bringing in 3.2. There is also a declaration to remove any doubts. For the others, that doubt was not there. Petitioner never raised it. So it was deemed that the post equivalent, since it's an equivalent post to the PTI, everything is the same, then it's supposed to be in the gap. Here he tries to raise an issue that it is not there in the list. Then the problem is clear.
Any replies, Sina?
Like, that cannot push, non-cannot push, whatever say there. When I was a joint director, this man, and he was allowed to hold the director of higher education. That is, post of director of education was remaining vacant at the relevant time. So he was allowed to hold that job. That doesn't mean that I have been posted there or I have been recognized in the post. He has been, when the post is vacant, he was allowed to, I have in my academic, the plan of the academic, again the para 7 and 8, I stated that page, in the affidavit page 4, I said that he was in allowed to hold the charge of higher education. While he was allowed to hold the higher education, his service at the in that cadre has been, there is DPI or 3 cadre, that is 3 that is higher education, secondary education, and elementary education. In that one he was regularized. Now the point has come that whether he has committed or not. Cadre in Indian also put there 3-1, that is DPI. DPI is bifurcated into director of higher education, director of secondary education, director of elementary, whatever they say. So that is the post of DPI. These 3 posts are DPI. Now you also will find on the day of transfer, that is on the 2027-21. The post of Bodo Media was upgraded. I learned earlier it was in the rank of additional director. The cadre was additional director.
That I've seen.
Yes. Then on 22/7 on the day of that accreditation, the petitioner was transferred to the post of Bodo Media. Now, why there is a necessary to issue the notification for enrollment? Because also that Bill 3.2 operates here only on 27/7/29, not before that. Though the post was updated, but it was given effect only when it was taken for
encadrement. And now you also will find the all these posts are different cadre 3, 1, 2, 3, 6 on a different cadre. Initial posts are inspector schools. Thereafter, in all the higher cadre, they have been either regularized or promoted. Here is only the petitioner is the only one who is the regular director. And you also report that there is no you also will find the respondable if there is accommodation to the post of director of secondary education. Only to accommodate her, that Melafite, whatever he said, there is no Melafite, we have stated there in the petition. Earlier it was to post the respondent number 3 to the forum media. You also will find the my petition is there.
You're alleging Malafite against whom?
No, just we have stated that this is the policy that or the behind the back the things was going on. Thereafter, the regular director has been posted in the board director, whereas the additional director has been placed in the post of regular director.
Okay. But Mr. M.K. Chaudhary, then it's senior counsel assisted by Mr. B. Sinha, then the counsel for petition. Also heard Mr. R. Majumdar, then it's standing counsel, secondary education for the respondents 1 and 2. Anybody for respondent number 3? Respondent 3. Respondent 3 is by way of
First,
and Mr. P. Nayak, learned counsel, appears on behalf of respondent number 3. You have anything to say on behalf? Stop.
Last one,
The petitioner belongs to the ST within bracket H of the state of Assam and was appointed in the cadre of inspector of schools. Stop. Draft. Petitioner was promoted to the cadre of joint director.
page 17. Page 17.
Cadre of joint director. Was appointed to officiate as joint director by a notification dated 12 May 2010. Stop. The petitioner, by another notification dated 14th March 2013, was again promoted temporarily to the post of additional director of Hills against existing vacant post. So, the promotion of the petitioner to the post of additional director was regularized by a notification dated 29th May 2013. So, by another notification dated 2nd March 2016, petitioner was allowed the service of the petitioner was regularized as Director of Higher Education with effect from the date of taking over charge. Did I say notification dated 2nd March? Stop. In the meantime, the Principal Secretary to the Government of Assam, Secondary Education Department, issued a notification dated 22nd September 2021, transferring and posting the petitioner as Director of Bhuto Medium and Other Tribal Languages, Assam, with effect from the date of taking over charge. By the response number 3. Who was serving as additional director, was allowed to hold the charge of Director of Secondary Education. Being agreed with the notification dated 22nd September 2021, petitioners before this court by way of the President. By a notification, where was the bifurcation order? By a notification dated 16th August 2005, the Principal Secretary to the Government of Assam, Administrative Reforms and Training Department, trifurcated the issued by the The Education Department was trifurcated into 3 separate departments, namely Higher Education Department, within bracket A, B, Secondary Education Department, and C, Elementary Education Department. By another notification dated 4th September 2021, issued by the Commissioner and Secretary to the Government of Assam, Education within bracket Secondary and Elementary Department, a new directorate, namely within inverted commas, Directorate of Bhuto Medium and Other Tribal Languages, close inverted comma, was created. And in the organizational structure contained in the said notification, it is provided that the Directorate of Bhuto Medium and Other Tribal Languages will be headed by a director in the rank and position of Additional Director of Education. Stop. Where was that order? Stop. Stop. By a notification dated 22nd July 2021, issued by the Principal Secretary to the Government of Assam, Secondary Education Department. The Governor of Assam was pleased to notify the post of Director of Bhuto Medium and Other Tribal Languages in the rank of full-fledged director. After new part, after the issuance of the impugned transfer order dated 22/9/2021, comma, the Principal Secretary to the Government of Assam, Secondary Education Department, issued another notification dated 27 September 2021. In catering the post of Director of Butu medium and other tribal languages in Schedule 1, within bracket, under Rule 4, close bracket, of the Education Service Rules 1982, subject to amendment of Schedule 1 of the within bracket, under Rule 4 of Assam Education Service Rules 1982. Stop. Under bracket, here and after rules of 1982 in short. It is the case of the petitioner that the rules of 1982 that under Rule 3 within bracket 1 of the rules of 1982, only the Director of Public Instruction is impaired and no other director under the school education has been impaired, and therefore petitioner cannot be transferred to a category to the post of Director of Bodo medium and other tribal languages, in as much as the same is not an impaired post. So, it is the further case of the petitioner that the petitioner is the only regular director, and posting him to a post which is not encouraged under the rules of 1982 would amount to sending him on deputation without taking his consent, and therefore the impugned order, transfer order, dated 22/9/2021, deserves to be set aside and quashed. Any other ground?
To accommodate the rest of the.
Further, the learned senior counsel for petitioner also submits that the impugned transfer order dated 22/9/2021 has been issued only to accommodate the respondent number 3, which is not permissible in law. Stop. Anymore, nothing. Para. Mr. R. Majumdar, the learned standing counsel secretary education, on the other hand, submits that when the petitioner was allowed to hold the charge of Director of Higher Education, he had no complaints with regard to the non-engagement of the post of Director Higher Education, and it is only when the petitioner is being posted to as Director of Bodo medium and other tribal languages that petitioner is eligible non-engagement of the said post. Stop. Learned council submits, when a standing council therefore submits that it is only an indirect way of challenging the transfer order of the petitioner to a post which is not interested to join, and such petitions and such arguments should not be accepted by this court. Stop. He also submits that the transfer order dated 29/2021 is passed without any malafide intention, and the authority who issued the order had the jurisdiction to do so, and therefore no interference is required in the impugned order dated 22/9/2021. So, I have considered the submissions forwarded by the London Council for the parties. New paragraph. The rules of 1992 has been considered by this court. Stop. Rule 3 provides the class and cadre of the education service, of the Assam Education Service. And then Rule 3.1, the Rule 3.1A prescribes the cadre of class 1 officers. Rule 3.2 provides that the service may also include, within bracket Roman 1, any post equivalent to a post in any of the cadres mentioned in sub-rule within bracket 1, and within bracket Roman 2, any cadre or post declared by government to be a cadre of the service. Stop. For let's see. The notification dated 27th September 2021, by which the post of director of Bodo medium and other tribal languages has been encatered in Schedule 1 of the rules of 1982 has also been considered by this court. A reading of the notification dated 27 September 2021, and also Rule 3 within bracket 2 of the rules of 1982 would clearly indicate that the post of director of Bodo medium and other tribal languages is an incatered post under the rules of 1982. Stop. Para. The only point of contention left is with regard to the transfer order of the petitioner. The transfer order dated 22/9/2021, which is being assumed by the petitioner in the present petition. Stop. It is to be kept in mind that judicial review, that there is limited judicial review while considering transfer matters by this court. Stop. An order of transfer of an employee is a part of the service conditions, and such order of transfer cannot be interfered with lightly unless this court finds that the said order is nullified or that the service rules prohibits such transfer, or that the authorities who issued the order did not have the competence to do so. None of the three impediments are attracted in this present petition. Stop. But in the present case in hand, the petitioner is being transferred to as director of both or whatever that language is. He is not being transferred out of Guwahati, and he is only to be shifted to a different room under the same under the same roof. Stop. The petitioner has no legal right to insist for being posted at a particular place or to a particular post. Stop. The petitioner holds a transferable post and unless specifically provided in the service rules, service conditions, he has no choice in the matter of posting. So, in the present case, it is not the case that the service conditions does not permit the petitioner to be posted to any other directorate. So, in that view of the matter, this this court finds no merit in the writ petition and is accordingly dismissed. However, with no order. Yes. Continue. Something.
7.
Okay. Director, some applications come up, were not allowed to appear. Some technical we approaches. In the meantime, no evidence have come from them. But in the meantime, last time it was submitted by another friend from the department that they have already verified all this. Application server, my name is not there, according to them. Yes, so because that's why last petition I gave the police not to get instruction, but I could not forget anyhow. As a matter of 15, 14, that is, I may be allowed to ignore only a little liberty will be given. If simple will come on. Otherwise, I do not want to it can be.
Mr. C. Barol and the counsel for petitioner. Request for withdrawal of the said petition with liberty to file a
Even in which, you are just. That's all right.
MS N. Fukan, the standing counsel, appears for the elementary education department. With petition is accordingly dismissed on
Yes.
withdrawal with liberty aspect.
Divya.
8 and 9.
The matter here is take your logic directly to the Indian order, page number 27.
Page,
37. The Indian order of the the last part, second last decision and read logic. In view of the above, it is opined that all the three Kamlesh Sharma, that is petitioner, is senior that the three personas on the task, that is the respondent here, in terms of receiving weighted scale of pay, but his BA degree obtained from Mayhata Charity BS College, Mayhata Charity is not acceptable as there was no recognition by NCTA in the name of Mayhata Charity BS College. Hence, Shri Prasanna Chandra Das is recommended for selection of regular headmaster of Golka High School. That is the issue here, Lord. The thing is that the recognition was not given according to the responses at that time. And because of that, his degree is not acceptable. Else, he is senior and he's entitled for regular headmaster. But because of this not given recognition, he's not entitled, and the respondent is entitled for selection of regular headmaster.
and NCT is before this court. NCT is before this court. You have filed your affidavit. Are you filing or no? Are you filing your affidavit? Because you'll have to answer this, whether this.
That's why, my lord, since they have also filed an additional affidavit, my lord, while they have also annexed certain documents, so I have to ascertain, and I have already communicated with the NCT. So I am waiting for further instruction. So it may be taken up after 2 weeks, my lord. In fact, it is also a covered case. Only thing is that I have to ascertain the veracity of the documents. So otherwise, they have a covered case. Regarding their additional affidavit, they have.
So you want to proceed today or not?
Yeah, it may be after 2 weeks. It will be better. Cover case, it's okay, but
Your good time, please. Heard MSA Dalukta and the council for petition. Also heard Mr. U. Shaman and the standing council, secondary education department. On request made by Ayala.
Yes.
Then standing council NCT. You give your date.
128, my lord.
That will not be 2 weeks. It will be something like 9th March.
Out of 9 votes,
It's up to you. You want later than that, after that? 14th? 14th. Meantime, you come. You can.
10.
10, 11, 12. Content discussion. This is the regarding the provisions. And the government, the finance department, software department. And that process is, and they have about all that are more than 100 pieces.
Only four pieces are here.
Yes, but how the process is name of compliance of the honorable court's order, they have incorporated some good personal smile by some other more than 100, and now 6, 7, 19, 19, they are not complying with the order of first.
We are complying for compliance with the order, and finance and that was more than 100 cases. And that's thing that the 111 regulations there. The post for creation of the post nursing. So some time will be.
How long you are going to take? Last time also you said the same thing.
This is the problem that situation more than 100 are there. We are trying nursing. We are trying nursing. We are trying nursing. For time given, I'll just say on personal time. This is the problem that all more than 120 or something. This is the problem. It's a daily problem. We are trying to comply. We're trying to comply nursing. Finance some queries that the creation of the post. This is the problem. We're trying to comply with which is the control proceeding. Otherwise, they are not. We're trying to. That's we're not. Very well. We're trying to solve the problem. Try to as the possible. That's right. It's last 3 years. That's good. That's we're trying as the possible.
From June, last year, June,
That's good. We're trying
from finance,
that finances to some persons and that again and more than 100 cases. Even sometime I'm trying.
maybe there will be 100 cases, but then the petitioners are before this court filing a contempt.
I know.
You'll have to take
Yes,
care of
that's
these
okay.
petitioners first.
That's right. So one thing I'm wondering why that because we have not minor. There are 4 cases here before we lost 3 cases are there. Another 1 case is listed because another 4. 4 cases were dear minor. By in the name of compliance of these orders, minor, they have incorporated hundreds of other persons minor along with the petitioners, and that is why the objections are coming from the finance department. That there be a proposal for the petitioners only minor. It will have been passed already minor.
But I had cycle and also for the petition. Mr. S. Buyan and the council applying for the response submits that due to queries raised by the finance department, the order passed by this court could not be complied, and they are taking all possible steps for early compliance with this court, for early compliance. We therefore place for another 3 weeks time. 3 weeks time. Prepares a note. List the matter up to 3 weeks.
No further action will be granted.
Contempt method that part. No, you cannot try.
No, we have to.
You'll have to do
We
it.
have to. We have tried. We have to. We have to. We have to. We have to.
If the respondents fail to comply with the direction passed by this court, the personal appearance shall be considered. Their personal appearance shall be considered. Their shall be considered on the next week. 10, 11, 12. Same order, same. This, the matter of. You said 3 weeks, no?
3 weeks.
17th March. Okay, heard, none appears for the parties. For the petition. Mr. S. Bora, Leonard Council for respondent number 2. Submits that the respondents are taking all steps for compliance of this court order and press for another 2 weeks time.
4 weeks. In the meantime, it will be done.
And press for another 4 weeks time. Prayers and notes, list the matter of complaints. Thus,
Yes.
2 o'clock.
Yes. But I would leave from tomorrow, so
So, yeah.
it's not in Kotamana, but that doesn't mean that whatever step in their affidavit, that may be considered. Because my problem is that I am retiring very soon. And in lordship on the earlier occasion, I still remember, I said that the issue was whether there was a break in service because I went from deputation to the ICICI Bank for 2 years. And I came a bit late because of some problem and they did not allow me to work for 4 years. I came to the court on the first occasion. I may tell the facts. So lordship wanted that the break in service part may be regularized. Because that part, because my pensionary part will be for no fault of mine, that part. So that was the issue, and my part was over. So just to recapitulate on what I said, I just want to start myself. The petitioner basically is a veterinary officer, and I won't go to the documents now. I just given an overview. He went on deputation after the government allowed him to go for a period of 2 years.
Which bank was it?
It was a private bank, but an ICICI Prudential. The order is at page, yes, at page 30. Page 30 of my report. Page 30. Can I read? I am directed to convey the sanction of the governor of Assam to the granting posse lien in respect of Rajiv Lahon, Assistant Distribution Officer, Town Milk Supply Scheme, Khanapara, enabling him to join in the new assignment as Unit Manager, ICICI Prudential Life Insurance for a period of 2 years with effect on the date of his release from his department, subject to submission of the undertaking to the effect that at the end of 2 years from the date of release from the department, he must revert back to resign from the parent department. Then, mother, what had happened? In the meantime, correspondents were there. They already informed me that since the term is over, you need to come. I immediately shot off a letter that since I was in a bank holding a post of manager, some financial thing needs to be in this. I may be given some more time because under the rules, posse line can extend to 5 years, subject to what the government. But the government refused and said that you need to come or your service will be terminated. It is after that period that I came and I joined in the year. So page 31, your lordship. Yes, in page 31, I paid for an extension. With reference to the above mentioned subject, I have the honor to inform that I have completed 2 years of my tenure in ICICI Prudential Life Insurance on 31/10/2007, and thereby the tenure of my posse name is also over on the same date. However, as I have been working after an important assignment which requires utmost attention and involvement, so leaving the organization in the middle of the process will put lots of problems which I feel will go against the organization policy and interests. Therefore, I would like to request Your Honor kindly to extend my posse lien period to another 5 years with the framework of provision laid out in the respect of posse. Now, this was not considered, and immediately the government informed me that at the next page 32. Can I read?
Yeah.
With reference to the subject, I am to inform you that you have completed 2 years of education service and ICICI Prudential Life Insurance. As the tenure of your policy line is expired on 31/10/2007, hence you are asked to join in a current place of posting immediately, filling which your service in the Department of the Government of Assam will be terminated with immediate effect. Then after this, I inform that I get released and I join. Page 38 is the joining. I come back. Also, one thing is very important. At no point of time they took up any disciplinary proceeding. With respect to the above mentioned subject, I have the honor to inform you that I have joined in the service and served in the ICICI Prudential Life Insurance Company Limited on the basis of a government approval letter dated 1st of December 2005. As I have left the parent department on the supervision of the policy game for a period of 2 years, which got expired on 31/10/2007. However, pertaining to my service in the Prudential, I have been bestowed with an important assignment to look after an independent branch, the Guwahati Silchar Police branch, and therefore, as a responsible manager, I was not in a position to leave the assignment midway. In connection to that, although I have received communication from the department and in response to that, I was appealing to all the existing office time and again to consider my request for extending Kwasai Gang for another 5 years. The last communication to the end to the Directorate of Dairy Development, Assam. Under the above, I plead to inform you that my assignment has come to an end prior stipulated time. Therefore, now I am willing to come back to my parent department, Assam, to serve the deputation department to the best of my ability. Therefore, I have the honor to request you to kindly consider my prayer to provide me suitable place before the officer. So this is a letter of 3/8/2009. Then what happened, since they were not communicating, well, my allegation was that instead when I got ready, they because of their inaction, they did not allow me to join. Possibly, what happens in government service till now, after 75 years of independence, if an officer asserts his right either in a court or any, that thing is there. Then you have gone to the court, that malice is there. But virtually all cases in the present level, malice would have been earlier also, but today also it's continued. That the fact that you didn't comply. Now, I have to go to the court, your lordship will come to page 48. If I may read that, can I read the last portion? I go on the facts, the facts are not disputed. Page 15. Once you can come to page 15. The petitioner was in the application. Your lordship will find at page 50. In the affidavit in opposition, such factual assertion of the petitioners are not denied. Means assertion by the department as well as department respondents. The Undersecretary to the Government of Assam, Animal Husbandry and Veterinary, the affidavit filed on behalf of respondent has also not stated relating to passing of any order pursuant to the communication of 10 issued by the director. The respondent to the director of Dairy, while admitting the factual assertion of the petitioner, as your lordship has stated that since the director is not the competent authority to allow the petitioner to resume his duty in the parent department unless necessary approval is taken by the government, the director would not be allowed the petitioner to resume his duty. Its letters were going on. In the affidavit in opposition filed on behalf of the respondent, it has been stated that despite the various communication issued by the department and received by the petitioner, he did not join his parent department after expiry of the period of Kwasi and rejection of the prayer for extension by another 5 years. It has also stated that Kwasi beyond the 2 years cannot be extended. The fact remains that though the director pursuant to the communication dated 25/8 issued by the Deputy Director to the Government of Assam, Veterinary intimated the Commissioner and Secretary of the State Department relating to the manner in which the period of absence from the service by the petitioner beyond 10/11/31/7 can be regularized. No final decision has been taken by the Commissioner till date. This being the position, the President is disposed of by directing the Commissioner to take the final decision in the matter.
it's needless to say that if it is active, we can evade investors legal remedy. But it was not required on my part to come to the court because for 3.5 years, in 4 years, they did not allow me. And whenever I go to the director of veterinary, they say the competent authority. When a competent authority doesn't know, I am a government servant. I am not dismissed. I have all the rights under the rules. So my position as a government servant, I might, if the lapses are there, that's okay. But that doesn't mean that you don't allow me to join when I am ready to join. And in fact, there are letters to the effect that the director writes to the government, we need officers because our work is hampered. On one hand, you say work is hampered. Another hand, when you want to join, you don't allow. Then your lordship will come to page 57. I'm coming to the end of it. This is the first impugn order passed by the Commissioner of Veterinary in the interest of public service. Can I read?
Yes.
Rajiv Laham, such and such, is allowed to join as chilling plant supervisor under such and such, with effect from the date of taking such subject to the following condition. The incumbent will not be entitled to any salary from 1/11/8, the release of the officer from the post till the date of joining. The incumbent shall bear the leave salary pension for the period of the preceding year. But in fact, they allow me with condition, but they are silent on the fact that the inaction of them, I was ready, that part they never say. So they say for the period, you will not be entitled. But if I have any problem, you have made a break-in service now because of my not coming within the stipulated time. You do it under the rules. I'm willing. But what about the period when I'm all along saying that I'm ready to join? What was the causing reason? So after that, your lordship, the final order is passed. This impugn order at page 16. Because 67 is the note sheets which I got to RTI. The regular order comes from the Joint Secretary, Animal Husbandry, leave admissibility. In inviting a reference to a letter, I am directed to inform you, page 68, that since 1/11/7 to 28/10/12, Sri Rajiv Laham was not in government service and nor on deputation. No, I was on deputation. Since no leave can be granted to him for the same period, he was allowed to join the parent department on 29/10/12. The period from 1/11/7 to 28/10/12, for which no leave is admissible, cannot be regularized, and it will constitute a break in service, and with which it will have to be treated as dies non under section FR 18, read with the government of India's instruction. This is as part of the finance document, finance endorsement. However, your lordship will find that in the order they talk about 1/11/2007 to 28. However, they take that period. What about the middle period when I was ready to join? They should have broken it into two pieces. That for that period, but the period for where I was, documents are there to show that I was willing to work, I was willing to join, and the director keeps on writing that we need people. And when I come and approach, the director said it is approval. That is they're passing the buck. In fact, Supreme Court has used the word the entire bureaucracy. Supreme Court's 1996 judgment, that entire bureaucracy can be, it's a harsh word, but it is relevant, can be made into three: file making, note pushing, and passing the buck. That process is there in there. But the fact that for any violation, I am amenable because I am a government servant. I am not disputing that I am above. But why are you not answering me that maybe that I was willing to join and I had to approach the court at the second on first way? Why should I have been able to go to the court? Because it was the duty. Because what happens, the functioning of the government is such in the present scenario that basically they won't take any responsibility, and they will want that since judicial review is there, let the citizens go to the court and knock the door. For genuine case, very good. But for cases where the government has the power to take a decision, why should the court be overburdened? So I had to go to court for no fault of mine. So because they were not allowing me to join. Now in this penalty which they have imposed, my prayer is very simple: that break-in service I am retiring. And this case has started, is dragging on. There was another counsel. My client had to shift counsel from 2014. So, I did not say why client shift files from lawyers. then I won't say anything. He comes to me about a year, 7 months back. Immediately I texted because he was with another council. Now from 14, now what I pray on the last occasion when this matter was heard, on 2 occasions your lordship had heard it, so only it was part of. Lordship had said that this part regarding the braking service will consider it. And because I want that part also, because now I will suffer. Because the pensionary part, I'm thinking of that because I have possibly very few months, less than a year. So now this part is dragging from 2000. So I possibly want that some, my petition, the relief sought for may be given. And the factual aspect is not countered. In fact, in the judgment of the Honorable Single Judge also, he said, it's an admitted fact. What I have done, I have not said so, that I sought for an extension, that period I could not come. So that's the case. This is somewhat substance.
Here for
I'm for Bachelor Department, respondent number 1 and respondent number 2.
you file your affidavit.
Yes, hello. Yes, hello.
Respondent
Rely
number.
upon my affidavit of respondent number 1, my lord. Was on Indian from by the order visit 1/12/2005. He was granted lien and in respect of enabling him to join a new assignment in Indian Manager ICICI Prudential Life Insurance Company for a period of 2 years, my lord. So it was when we come to annexure 1 of my affidavit, page number 8. I am directed to convey the sanction of the Governor of Assam to the grant of partial lien in respect of the Rajesh Lama, Assistant Distribution Officer, Town Milk Supplies in Khanapara, Guwahati, enabling him to join a new assignment as Unit Manager ICICI Prudential Life Insurance Company Limited for a period of 2 years with effect from the date of release from this department, subject to submission of an undertaking to the effect that at the end of 2 years from the date of release from the department, he must revert back or resign from the parent department. It is clearly written in the first one there, I love that he must revert back or he will resign. And after completion of 2 years, the petitioner has never approached the department. The department has made his their communication that yes, 2 years is already completed. Secondly, my lord, paragraph 6 of my affidavit, my lord. Then, my lord, annexure B, my lord. It is written that clearly stated that a petitioner must revert back to the parent department after completion of 2 years from the date of release from this department, and the same has been communicated by the department respondent number 1 on 4/2/2008. Now, you may kindly turn to page number 9, annexure B of my affidavit. I am to inform you that I have completed 2 years, completed 2 years of professional service in ICICI Prudential Life Insurance Company. As the tenure of your partial year is expired on 31/10/2007. Hence, you are asked to join your parent place of posting immediately saying which your service in the department under the government of Assam will terminate with immediate effect. This letter was issued on 4/2/2008, where 2007 to February, till February, he has not made any communication from his side, kind of. But he did not, made any communication from his side that he want extension or anything. He didn't make any.
After 31/10/2007.
After 31/10/2007, it was expired on 31/10/2007. And department has issued this letter on 4/2/2008, kind of.
One, your lordship's name. I just want to clarify first. The submission was made that from 31/10/2007, and no communication was made. The commissioner was informed on 31/10/2007 about it. It is page 31. It is documented. Possibly the directorate level don't know. The commissioner, I informed the commissioner itself. It's recorded on the day only. Page 31 is my reply. So it's not that I didn't reply, I replied. And in fact, my submission was also that if you had case against me, you could have brought discipline. You acquiesced, allowed me. Now you cannot say you were not informed. The page 31 is the annexure, 6 is my reply. Just a clarification.
Proceed.
Then, madam, consider representation on 17/2010 by the petitioner, paying for extension of procedure and grant of leave for regularization of service beyond the term of procedure. That is paragraph 16, statement is in paragraph 16 of our application resolution, page number 4.
Yes.
Petitioner paying for extension of procedure and the grant of leave for regularization of service beyond the term of procedure. The Animal Husbandry and Veterinary Department has endorsed the file to Finance Department for their views. Finance Department regretted the proposal with a suggestion to move Personality Department. Personality Department advised to move the Finance Department once again for their considered views. The Finance Department reiterated their earlier views, reflecting the extension of terms of the procedure. Annexure 6 is the letter of 17/2010. And it's the kindly turn to page number 10. This is the letter given by the petitioner. Application, the petitioner's application 17/2010, my lord, which was by finance department with a view denied to consider the matter, my lord.
Then
Then, my lord, on 15/11/2011, as final decision to be taken the matter in the seeking views from concerned department, and finally, by the notification dated 29/10/2012, allowed the petitioner to join under TMF SS Khanapara. Subject to the two conditions, the incumbent will not entitled to any salary from 1/11/2007 till the date of joining. And second, the incumbent shall bear the leave salary and pension contribution for the period of service in procedure. Annexure B and E, my lord, it is the terms and conditions. These two conditions in our joining letter, approval for joining, my lord. And after knowing these two conditions, the petitioner had joined the service. And after joining, now he is again praying for. He knew that these two terms were imposed on him, my lord. And after joining, now he has paid these two, that his area salary amount. Page number 16, my lord, sure.
Sure.
Election, I, my lord. The respondent has paid for extension of time for executing the decision of Honorable Court Order of 15/11/2011 in the petition number 631 of 2011, my lord, where the department has, that I am directed to inform you that since from 1/11/2007 to 28/10/2012, Sri Rajesh Lahore was not in government service and nor on deputation. And it is not deputation, my lord. He is willing to go to a private department. It is not deputation, it is a lien. He was on lien, my lord. Hence, no leave can be granted to him for the same period. He was allowed to join the parent department's post on 29/10/2012. The period from 1/11/2007 to 28/10/2012, for which no leave is admissible, cannot be registered, and it will contribute a break in service, and it will leave to be treated as died under FR 18. With which the government of India's instruction inserted under FR 18. And the finance department, there's some instruction that in this pension schemes, we are not the totally based on the finance department decision on these matters. This is the financial parties there. Our principal have already asked him several times for joining. He was on lien, he was not on deputation, madam. So this financial limited to join the department, and now after knowing that these conditions were imposed, he's joining, and after that he's praying for exemption of these conditions.
No, the last occasion I want to make it clear that my grievances on as well as a break-in service, because I lose that part, and the lordship being a equitable court can always balance the equities, and that was the understanding. So those which are not permissible, I cannot force the court.
Yes.
Mr. Ardor Pujari, supposed to appear for this matter. I'm very on behalf of him. The lordship is amidst hearing in court 19, so he wants to submit.
Tomorrow? Yes.
But I am on leave.
No, doesn't matter. I'm just going to hear him and
Yes,
then
sir. So I am only present.
doesn't matter.
He'll be
Are you
present.
sure tomorrow you can?
Yes.
It's already my turn. This is my time. I had a word with Babu Jale. He is very helpful. He only told me.
DK Das, Council Competition. Also heard MS M. Kakati
Correspondent partner.
on request made on behalf of Mr. Babu Jai. This the matter again on tomorrow's 17th. Is it possible to come up? No problem. And MS also heard MS Didi Baba. You have anything to say?
But your lordship is completing after the.
Yes.
Obliged.
No point keeping on
No,
getting
because I-
everything.
Because I am suffering from 14 days case. Obliged, lordship. My, you will be there, Mr.
Doesn't matter. Oh, we make it Monday. Babu Jari,
Any day of
for a hearing date, maybe better.
Yes.
Tuesday, 21st. That will be better. I'm having it on 21st. It does.
Lordship,
21st.
yes, I won't be
No, doesn't matter. I think it's better. Tomorrow. Yes, please.
Actually, this matter, last year, I was ready. I observed for 2 days. Somehow there's a gap in my notes. We just come up. So Mr. Rajesh Pranjal is here in this case. First of all, here, I had talked to him. I said, see, when the case was pending, the client is retired, no impression. The witness submission today, DC goes, all right, continue. Submission today, he make submission next Tuesday. So that way I will make my submissions. So she's hard on it twice. Of course, not possible to remember. So many cases come up in between my door. But I've given list of days, my God. I put a dash on the questions. It's not there 5,000. I put extra. My Lord, this is the fourth litigation by this petitioner. My Lord, before Lordship goes to this,
Just 1 minute.
my Lord.
Dibrugarh University, who appears?
Yes, Mr. Rajesh.
My name is Rajesh. That's it. The matter is going on. Yes, on lakes in Port Number
Who's
6.
appearing?
I'm Muzindar.
Rajesh Mahindra.
I am very one. I'm Muzindar.
Oh. Then,
So I had talked to him. My Lord. He said, I said, I'll make my submission. He said, okay.
Yes, yes.
And yes, so we make submission. He said, maybe next Tuesday. Yes, so let me make the submission today. My Lord, before Lordship goes, let me please act in short. What happened actually? What is this disciplinary proceeding? Why the removal? In Dibrugarh University, my Lord, they're supposed to construct 2 hostels. For 2 hostels, tender was floated. Work was granted to 2 persons. For construction of the building, the area was low-lying area. So the question arises, it has to be written. That has to be filling up by art filling has to be there. So art filling was done. Now, according to the authorities, decision authorities, they say there was no approval for this work by the authorities, and also there was no tender called by the petitioner to allow the work. There are 2 points, my Lord. There are 8 charges. It's open to fight, but this basically concerning this only. There was no approval or the sanction for rupees 16 lakhs each for 2 works. And the work was allotted to the particular person protector without tender, my Lord. That's the issue. Now, I will show the Lordship's, my Lord, in this one. In Dibrugarh University, for construction of the hostel building, there was a tender. There's no dispute about this. But so far, the art filling work is concerned. The document I will show you, Lordship's, my Lord. For the evidence of the officials, I'll show is the Vice Chancellor. There is shortage of time. Vice Chancellor said, you go ahead, you start the work, you do the work. It's on that basis the work was done, my Lord. There was no tender. This is the issue. But I will show from the document, my Lord. From the evidence, the Vice Chancellor said. If I can convince your Lordships on these 2 points, basically I think I leave the Lordship for Lord of Lordship pass, my Lord. That's up to your Lordship, my Lord. But that is the process. That way I proceed in this case, my Lord. Now, Lordship, I leave it. On 31st of May 13th, Shawcott note issued containing charges, my Lord, the petitioner. There are 10 charges. Petitioner submitted written explanation with limited documents furnished to her. Petitioner was placed under suspension. Honorable Court set aside suspension order and direct for reinstatement of the petitioner. First round. Petitioner again placed under suspension without reinstating her in service. Honorable Court set aside in first suspension order. Second round. Inquiry committee submitted its inquiry report to the registrar of the university. Observations and suggestions made by the inquiry report. The petitioner was asked to submit detailed presentation to the inquiry report. Written representation submitted on the inquiry report, including statement of officials Sanjeev Kumar Sharma, very different, and other documents. My Lord, from here, this is the reply. In the last round, the next is Lordship will see. Lordship is directed. Denumerated inquiry you start from the time of submitting the inquiry report. And from this representation, you start. Next page, that is. My Lord, then statement of official witnesses. Sanjeev Kumar Sharma, Assistant Registrar, who internally stated that the then Vice Chancellor, who happened to be chairperson of the PC board, used to issue verbal instructions to the university engineer
immediately start the work, including the connected earth filling works through the contractor who has been chosen for carrying out the construction of the building. The Vice Chancellor himself at times instruct the contractor who have been able to the work to go ahead and start the work immediately without waiting for formal orders. That is what my next. In cross-examination, he stated that period during which the work was completed and the bills were finally paid, taking the data of all instruction patients to go ahead with the work as the date, initial date was 1 month. Now they say, you're showing the fine, in 8 days, how will you complete it? It's not like that. Actually, my sister said, go ahead, sometimes it happens like go ahead with the work, formal work will be issued. Then when they start the work, he completed the work within 1 month, but the formal work was issued later on. So they say, now in 8 days, how will you complete it? It's not that. It's the license nothing. The evidence officially. Next, my lord. Then, my lord, penalty of removal from service imposed on the petitioner. Thereafter, we came to the losses, my lord. Then on 28/3/18, this honorable court again set aside and quashed the order of removal of the petitioner from service, as well as resolution number such of the Executive Council of the University. Respondents also have been directed to proceed against the petitioner from the stage where deviation from the established procedure have taken place, and the university shall give a consideration to the reply of the petitioner submitted against short notice dated 5/7/16 and arrive at a reasoned conclusion as to why a reply should not be accepted, and thereafter proceed to the requirement of provisions of the ordinance of the subject. This is what I want. From here today, I make my submission. I will show you the next point of the Executive Council of the University in a special meeting purportedly opined that charges against the petitioner has been proved. Rest of the university to notice the petitioner that Executive Council, but these are the formal orders issued by the minor to remove it from service. Now, just as a cursory glance, I feel the losses based on 41 the charges of the petition. 43 stop. Page 40. That we did the first charge. Basically, relating to charge 1 and 2, all the charges. That while you were holding the post of university engineer, planning and construction branch, Deputy University since 3/3/04, you have committed gross irregularities and deliberately in breach of the duties and responsibilities delegated to you to manage all the matters related to the planning and construction branch, Deputy University. You dishonestly and without sanction from the competent authority allotted 2 numbers of art filling work related to development and raising of land for the proposed construction of a hostel building of University Institute. 2. You were holding the post of University Engineer, Planning and Construction branch, Deputy University. You illegally issued work order to 2 numbers of contractors amounting to 16 lakhs and more to 2 works without following the due procedure in allotment of contract work. The total amount of the illegal allotment of work amounted to such and such 16 to 16 plus 16. From verification of the records, it was found that you have not invited tender for 2 efforts in architecture work and arbitrarily allotted the due amount of contract work as per the own preference of such. 3. He have also committed gross violation of the authority by issuing work order without taking prior approval from the authority. But these are the same thing. Therefore, next page also. Please, next page. Page 54. Serial number. That in gross violation of the authority, the work order issued by you as supply agent is totally illegal and unjustified. And you issued the ulterior motive of wrongful gain for yourself imposing wrongful loss to the university. From the available records of measurement books, the work was executed as a composite work of artwork and not supply agent as issued by you. But this is what my name. Now, my God, I shall take the losses. These are the repeated basic. No sanction, no authority, no tender. The removing 3 things there giving this notice, my God. Now, one simple I shall show you notice by the work order.
Please come to page 198 of this. 198. This 198 question is got it, my lord?
Yes.
Yes. This is the work of the Office of the Registrar, Revenue University, to Rajkamal Das, contractor. Dear sir, kindly mark this, my lord. Dear sir, you are required to supply the following materials immediately to the construction with Mrs. Devani to this petition here. Deputy University Engineer, Deputy University, you will be paid such and such. Bottom left side, my lord, kindly come approve the amount of rupees, kindly see. Bottom left side, 16. Or should I say, my lord, approved amount. Now please come to page 190. My lord, 190, come to 187, my lord, first. 187. And show the numbers. Also, you see that in that page, approved amount 16 lakhs 109 PC board meeting. In that page, the work order page 190. Now, in 198 PC page, see the first line, very first line. Minute of 109 meeting of the planning and construction group. Also, you see my. So in the shopper notice, they have said there is no approval, no sanction. This is the sanction. Now come to page 190 page. This amount I show. Except this amount. Resolution number 32. Resolve that the estimate of rupees 16 lakhs only for development of construction site of the proposed construction hostel number 1 building university be approved. Resolve further that expense shall be made from such and such development fund and at least 1 feet on top with earth field. So should say this. Then development of construction sites of such amount. 16, 18, etc. Same amount. Same amount, my lord. So resolution 30 the same thing. So in the shopper's notice, Lordship is saying in page number 43, they say without sanction from the competent authority allotted to works. It's absolutely incorrect. Here it is approval is there in PC Go. Purchase and PC. Planning and construction board. In the planning approval, then minor Lordship will be knowing who is the chairman, minor. The vice chancellor is the chairman of the construction board. He himself is there. In secretary, actually secretary is the registrar. There they are. Then how come this shopper notice issue to me saying that there is no problem? It is from there it comes, minor, absolutely clear. Number 2. Now one sample I share to you also. Please come page number 276. 276. Look at discrimination I share. How what they have done. 276. Last but one page number. Even 276 also. 276 please come.
Yes.
Now, the work order which I have issued in page 119, exactly identical to page 276. At the very first time, you are requested to supply the following material. And see the description, my lord. Rising low site with approved soil obtained from outside by truck carriage, including breaking plots, dressing, etc. Complete, including paying necessary land compensation, municipal gate fees, if any monopoly, duty, etc. Profile measurement to be taken and 12% deduction is important. 12% deduction for changes to be made from fuel quality. Now, approved in 150 PC board meeting. What should I see? In the right side, kindly see who signed it. Assistant University Engineer Prashant Sharma. Please. He was my assistant. Exactly because he is a system university. Exactly identical work order. He is issued. See the next page also. Next page. Same supply. That means that part which was carried by the truck, that's taken as supply one. It's not the construction part. So this gentleman, esteemed engineer, who was working, you know me, my lord, as my subordinate officer, he has issued a similar work order. Everything same. No support notice, nothing affected me. What it is me to me. It was done to me. It was done because of certain other reasons. This is what discrimination, like postal discrimination. If it is universal, applicable to everybody, then it will be applicable to him also. Because that was the system in the university. The conductor who does the construction work, the same work is given to him in fill up the work. Normally, my God, it is easier actually to work. You fill up the work, and they are, and they will construct building. That's what is happening here. Now I show you your worship. It is the worship pilot. Please come to page number 250. Your worship's last order. This is our post worship. 250. I will just. Please come to 237 page, the judgment. That was the last judgment by this honorable court. Page 237. I got paragraph 20, let me take a look. Or paragraph 98, read from paragraph. In such view of the matter, as to the shorter notification against the proposed penalty was not issued to the petitioner before passing the order of renewal in service. This court is of the view that procedure adopted by the respondent authority is in deviation of the statutory conditions of ordinance of 2000 and as such the same issue. Next, paragraph 20. Further, it is also the proposition of law that when the delinquent employee gives a reply to the inquiry report, and the same reply is to be given in due consideration by the decision authority before passing any order of penalty against the delinquent. In the instant case, it is noticed that although the reply given by the petitioner against the shorter notice was shown to have been sent to the members of the council, but apart from the blank statement of the resolution 14, then the reply given by the petitioner does not disprove the charges established in the inquiry. No other order has been brought on record to indicate that disciplinary authority had given a due consideration to the same inquiry. From the above point, from the same point of view, also a procedural aberration is found in the method adopted by the respondent authority in arriving in the order of renewal of service. Then, from the reasons as indicated above, the order of renewal from service dated 24/10/16, as well as the resolution number 14 from the Executive Council of the Victoria University in its 222nd meeting held on 24/10/16 are set aside. As the interference is made on a technical aspect that the required procedure has not been followed, it is provided that interest of justice be met. If the respondent is to Victoria University now proceeds against the petitioner from the state where deviation from the established procedure had taken place. Accordingly, the Victoria University shall give a consideration to the reply of the petitioner submitted against the short notice dated 5/7/16 and arrive at a reasoned conclusion as to why the reply should not be accepted, and thereafter proceed with the requirement of provisions of Article 32(4)(6) of Ordinance 2000. It is clarified that the implications of the order of renewal being set aside is that petitioner stands restricted in service, but thereafter the authorities can proceed against the petitioner as part of that was the order. Now, since your lordships have, they will start considering from that stage where I submit my reply, and they should proceed the reply from that stage, my God. So although the petition looks very big, but I
Try to make it short by what I can do. My reply, you know, should find a place, my page 130. 130. My God. Before I take the lordship to my plan, one thing I think I must bring the lordship notice is the observation made by the legal committee. The previous page 120. That I'll bring to the lordship to this page. So they become convenient, my God, to bring it to such stuff in page 120. The legal committee. Just let me read once. 129 page number.
Yes.
Right. From the materials on record and the evidence used by the parties before us, we have noticed certain aspects in general which we would like to place here and now. The PNC board is a statutory authority of the university, and the vice chancellor is the chairperson of this board. The PNC board retains the authority to monitor and supervise all types of construction work of the university. Such. 2. The university engineer is the executive authority and is responsible for the execution of all types of contract work under the control and supervision of PC board. The PC board approved 2 works involved in this inquiry for execution on 8th. Worship said in the shop of the my own repeatedly they are saying no approval, no sanction, my God. Inquiry committee says this. The PC board approved 2 works involved in this inquiry for execution on 8th. However, the board did not provide any further guidance for execution of the works, and no direction was given to the university engineer for following the tender process. The PC board might have considered it unnecessary in view of clause 34 of the regulations and expected the university engineer to follow their process of execution of such works, which is by way of inviting tenders. However, there is no decision of the PC board that APWD board should be followed on all contract works. This is one of the reasons we are finding. There's no specific guidelines that you offer tender for the marketing work also. Next, the university engineer had given a go by to the tender system, picked up the contractor offer choice, and without supervising the work done practically in the field, and without maintaining proper record, raised the bill, forwarded for payment, and finally made payment again without electing the shrinkage for you, and finally allow the contractor to work. Next, the copies of the work orders so issued by the university engineer were appeared to have been forwarded to the vice chancellor and the registrar and the account section of the university. And the chairman and the vice chancellor is the chairman of the committee. Registrar is the secretary. However, none of these authorities raised the point as to how the work orders could be issued without resorting to the tender process and on what basis contractor had been chosen by the engineer. Obviously, my lord, I'll show. In the vice chancellor has said, "Oh, finish the work. Time is very short," and the official says, "I'll show." Next, last paragraph. While forwarding the bills of payment of finance and accounts branch, it was responsible of the finance and account branch to scrutinize the bills and examine all relevant aspects, including submissions of all relevant papers, documents, along with the bills, which should immediately include tender papers, proper statements, sanctioned by the PC board, proper record of execution of works, as well as recording of measurements in the measurement books, etc. In the absence of any of these supporting documents, the finance and such was required to raise objections. My lord, in page 131, the suggestion part can be done. Otherwise, there's no point in reading on this. Page 131, suggestion part. We therefore constrained to hold that there were lapses on the part of the finance accounts of the university, as well as internal auditor, and at the same time, there's a lack of proper vigilance on the part of office of the registrar of the university. Then we therefore suggest as follows. For the proper functioning of the PC branch of the university should issue circular laying down guidelines detailing the procedure to be followed in execution of construction works, right from the point of preparation of estimates till the payment of bills. For this purpose, the university authority may adopt the rules and procedures followed by PWD of the government of Assam. This will ensure transparency and prevent irregularities, misuse of authority,
fund by the concerned officer of the branch. The university authority may appoint, engage in a temporary basis an officer who is an expert in execution of civil construction work such as. The university authority may also take position such as. Next slide. The university should also issue orders specifying the duties and responsibilities of the university engineer and other staff of the PC branch for better accountability, smooth function of the branch. The authority may have to remove to the office order areas officer. Similarly, the finance accounts branch university also appropriate guidelines should be issued regarding processing the contractors' bill, release of payment, their officers will be taken impart proper training with officers and the branch also. Who make these guidelines suggestions because we have learned in the inquiry that because of lack of specific rules, guidelines, then there is a specific procedure for execution of work, passing of bills, there is informatively executing work, various works, and the officers are left to guide themselves on the rules. That's the inquiry says, my God. There is a sanction, there is a approval, the important part I should show you. Now, since the lordship is directed, they should look into my reply to the shop of notice, my lord. What is my reply? My reply you should find, my lord, page number 134. It starts on page 133, my lord. It starts from. Now, this contains, my lord, page from 132 to 225. Not possible for lordship to read. So what I done, my lord, I made notes of this. This page is very important, my lord. Rest may not be. Because the petition of themselves, like their written, my lord. Use pages. She has written. Page 130 to 134. Please just have a look first on page 30.
Yeah.
132 page number second graph. The PC board approved 2 works involved in this inquiry for the execution of 8 However, the board did not provide any further guidance for the execution of work, and no direction was given to the university engineer for following tender process, my lord. This, my lord. This also in the inquiry report, and also the resolution was passed in 109 meeting of the university, my lord. In page number 190, I have shown my lord. Now, second graph. From the above, it could easily transpire that PC board, where the vice chancellor is the chairperson, registered with the member secretary, is responsible for placing guidelines and advising university engineer to go in the right direction. In absence of this, university engineer cannot be charged for the same and whatever answer. Right? No, please come, please, 130. I won't read the entire page. The given part. 130, next page. First paragraph, third line. I would like to submit that prevailing procedure to carry out construction work was that estimate for the work was prepared either by the firm or an architect by a site in charge, then placed in PC board for approval. When the PC board approved the estimate, and after approval of the manuals of the PC board by the vice chancellor DC in a file, action to be taken by the university engineer. Tender was to be made for construction. In the pilot. Second part, my lord, for the middle. In item number such in the nearest one meeting, April for the estimate allotment of the construction over next line. Also, my lord, in AUE, Engineering Engineer, invited tenders for institutional building of duet before the approval of the estimate by the board in as per further order of the PC. The duet campus where these buildings are to be constructed was a petty field. So vice chancellor already verbally ordered R Dash, he is a contractor, to raise the bid from before construction work started. In the same meeting, PC board, he approved only the estimate for raising the low side. So if the tender had been invited, there must be given to the engineer either by PC board or by authority of the university. My lord. Even the page 36 in details, same thing, my lord. Then, my lord, in page 136, 137, I have written, my lord, possibly see the similar works in last page 276 by esteemed engineer is written. Same order, only his signature and the date is different, memo is different. Same thing he has done. It was built up, construction was done, my lord. Nothing able to. That's what I have written in page 137. Then, my lord, now page 138, please come once, my lord. Page 138. Second paragraph, 130. I have done nothing wrong by obeying BC's verbal order
as he is the chairperson of the PC board and has the supreme power of development artwork. I have shown all these to the inquiry committee and copy of the work order, but the inquiry committee simply ignored the fact that Honorable Chief Justice has power to develop the work order. Obeying the Vice Chancellor Barber order, issuing work order as a supply order to the original contractor of the hostel building for utilizing government fund for such hostels cannot be gross irregularity, illegal or arbitrary. Tender system is specifically for construction as per clause 34 of the State University. But this art filling work is not a construction work. My lord, I will show you lordships. The registrar of the university, he gave evidence before the court saying this is a supply work. Art filling is supply work, it's not a construction violation. So they are saying if it's a construction work, that has to tender. But the registrar himself is saying that the evidence is supply work. And the moment it's supply work, it is not necessary. Also, a similar example is cited in Annexure 8, page here, which of the page is close to work order by law in 276, ST Engineer. I did not choose contractors of my own, but instead the works were allowed to the original building contractors who got the construction work of the hostel by the process of tendering. My lord, that's what she's saying. She said the contractor who constructs the building, hostel building, my lord, the same artillery was given to him. He can commit it to work, and that's the reason, my lord. Now, my lord, they remain with 130. Please come to 192, my lord. 192. This is the report. This is the evidence during the inquiry by Sanjeev Kumar Sharma. He was a staff of the university, my lord. He gave evidence before the inquiry committee. And what he said, that this is very vital. Why am I saying so? Because what you will find when the after Washington passed the order saying directing the authority that you look into the reply, you consider the reply and pass an order. Now, when the interim order was passed, you being from the subject, Washington will find they have not given any consideration to these points. These replies, I put this thing, I put the reply, my lord. Even this evidence. What is the evidence? My lord. Page 192. I am an employee of the Delhi University and working as a assistant registrar. I have come here to depose as per request of Sripalipur University Engineer. I know this that this inquiry has been initiated to implement charge of the day against Sripalipur University Engineer. I was promoted to the post of accounts officer from the post of divisional accountant on 17/12/20. Prior to my promotion to the post of accounts officer at the university, I was posted and working as divisional accountant in the PC branch of the university. Even after my promotion to the post of accounts officer, I was discharging my duties of the divisional accountant of the PC branch, University. Because of non-availability of officers in the PC branch, I was entrusted with those dual responsibilities, and I was discharging duties for both official office simultaneously. That is divisional accountant as well as accounts officer. As the divisional accountant of the PC branch, I used to check and forward all the bids pertaining to the works as well as supply of the PC branch. Accordingly, I checked and forwarded the bids pertaining to the art filling work of the dual campus. I do not remember how many numbers of bids pertaining to the art filling was in before, checked, forwarded by me to the university engineer. So far, I can remember the one bill of rupees 16 lakhs and odd, and the bills involving entire amount of the work were checked and forwarded by me by my end. Bill used to come from before me after they were prepared by the billing assistant, checked by technical assistant. The technical assistant happened to be the assistant engineer. Below me, my lord. I am a university engineer, and below me, the assistant engineer. While checking the bills, I used to check the data recorded in the measurement books with the estimate and compare those with the estimate prepared by the PC board. The meeting books containing the details measurement of the work done and the value of the work, and also the abstract of the bill were mentioned in the end of the recording data. Therefore, the bill before which is forwarded to the final approval needed to be checked by correlating its data with the measurement books, which I used to do. Next is important. But let me get this. From 2002 to 11, I used to reside in the official quarter allotted to me, which was located in the front side of the prison. There the lower lying and was submerged underwater, and sometimes the floor of our rooms were submerged by water. The development of the site started in the year 2009. In those quarters were removed after March 2003. Therefore, the construction work first took place. This is important. Page 193. I used to be present in the PC board meeting to assist the officer with the records. I can remember that in such meeting, when discussion took place regarding the construction of building in the Druid campus, the then Vice Chancellor rigorously insisted that the work must be completed as early as possible so that students can occupy those buildings by the start of the new session of the month of August 2011. The wish of the Vice Chancellor, as demonstrated, was appreciated by all present in the meeting as well as university students. Accordingly, the work was subsequently completed at a faster pace. I was not involved in completing the process in execution of the work in any way, and my duty was only to check and forward the dates when those came before me. The then Vice Chancellor, who happened to be the chairperson of the PC board, used to issue verbal instructions to the university engineer to immediately start the work, including the connected art filling works. So contractor who has been chosen for carrying out the construction of the building, I submitted earlier. The contractor who constructed the building, the same art filling is built. The Vice Chancellor himself at times instruct the contractor who have been handed the works to go ahead and start the work immediately without waiting for one order. Just sit. Is the staff, my lord, he is saying, because they said in 8 days, how could you finish the work and the bill was paid? It is not that, my lord. Informally, it is the Vice Chancellor, he on verbally stuck, but that's the reason. Now, my lord, the cross part, my lord. It is to the cross, my lord, not first, second, but fourth there. The time period within which the work was completed and the bids were running paid, taking the data of following instruction of the Vice Chancellor to go ahead with the works, and the initial date was about 1 month. That's what, my lord. My lord, this is one document, my lord. And the PC board's meeting approval, all these things I have stated, my lord, in my reply. Now, as per Lordship's direction, my lord, those were not considered. Now, if those are not considered and the penalty has been imposed on me, my lord, then what's the consequence? The consequence to say that, my lord. Now, my next submission will be my lord. Now, suppose the Lordship set aside, assuming my Lordship pass an order, my lord, assuming. Found that they have to consider it, my lord. The Lordship will pass order only for the setting aside, not since I am retired, the still benefits. What again there? Because in one case of December, what I think it was my lord. When the judicial office is retired, my lord. The Lordship has said only that about setting aside the question. So, let me place certain decisions, my lord, which Lordship will find in my list of dates also I have given. The written argument, my lord, I have given a written argument. Exactly what I have said, my lord, submitted, my lord. Everything.
You have a written document?
I have given, my lord. Everything is there. I have in the office, my lord. No process it is, sir.
So process.
Yes. In the filing section, I find it, then it was brought to your lordship.
It's here also.
In the main file, my lord.
Yes.
I don't, before Lordship goes to this page, my lord, just travel a minute to Lordship. In the petition, please come to page 260. 260.
268.
Yes.
Yes.
Kindly see this one. This is my lord, evidence given by the Milananda Narayan Datta. He was the registrar of the university, my lord. When they issued me, my lord, notice on the penalty, my lord. Then suddenly they reply. In the reply, I have given this document. So what is the document? This document is I got a defamation case against the registrar. In that case, he gave evidence, and that evidence was also defined. In page number, my lord, 272. 279. Yes. Second factor, I do not remember whether there was one line meeting of the PC board resolution group. Next, it is true that 109 meeting held on 818 resolution number for such for an amount of rupees 16 lakh 16,000 each piece of work. I don't, they said not approval, he admits here. Then our allegation was that articling was approved by PC board, but work order issued by the corporate was not in accordance with the law. To the point in that. The work order issue. University engineer issued the work order in favor of the contractor whom the construction was given. The construction work was given to the group, but articling was given to individual names. There is a registered contractor of the university. Name of the group in the name of farm as well as the individual also. Raj Kamal and Monu Sharma has got their name registered as contractor in their farm's names also registered. Articling work was given to the registered contractor. Next line, I want to next page. That's important. One line. Articling work was treated as supply work. In construction of the building is still construction work. By God. The moment see this gentleman, my assistant, in last 2 orders he issued. Same order issued as a articling work, as supply work. Nothing against him. He says this articling is supply work, registers. But when I did it, now it's an offense for me. That's what I said. That will make a note of this one. My lord, one contractor, my lord. I have given in my written submissions, I have given stated the details, but the page is not annexed, my lord. So I have to do the page. This contractor, the official says just giving license or giving order instruction. Now see the contractor says the contractor. The petition is there, I state district is there, but practically lost against my lord. My lord, defense witness number 6, Manoj Gohai. I am a businessman. I have come here to propose for the university engineer, Dipali Kubar as representative by her. I know about the supplement of the inquiry. My lord, next lordship will skip my lord 1, 2, 3, 4. About 1 month, lordship can got it. Middle. About 1 month prior to the issuance of this work order, I was verbally asked by the vice chancellor of the university to execute the work, and on the basis of that verbal instruction of the vice chancellor, I started the work. By not. That is the evidence of this Manoj Kumar Gohai. In my reply, I have stated that I put in the paper. But in the resolutions, my lord, resolutions, I think I should bring to worship from this my lord. The resolution, what resolution they passed. Let me show to worship, my lord. Page number 249. Just one thing. By lord, in 239 page, 239.
Yes.
After Lordship has passed the order now, this particular order was issued by the authorities. My lord. Now, I will make the submissions, my lord. In this giving order, in the Lordship can see that from page 230 and bottom, my lord, to consider and take appropriate necessary action against the public to the right of the body from the
Where are you reading?
my lord, page 239 bottom, my lord, in the agenda.
Yes.
The agenda, just below the agenda, to consider discussion and to take appropriate necessary action against the public in the right of the body to order 853. That order, my lord, to they start again from the state of reply. Now, my lord, if the Lordship can carry this entire order, Lordship will know and find. 3 points, Lordship will never find. Number one, on my submission, that PC board has approved the listing of 8009, and there are 2 witnesses. One is official witnesses, one is official staff, one is a contractor. Those 2. Then I also showed the Lordship space to 76 to 77 minor. Then the testing area is similar ones, nothing happened with me. It was only on me. Those things have not found place in the entire chart. Now, in chart number 8, one thing they said, I got deducted the shrinkage by 12%. It is in the order it is there, nobody does it. Even the subsequently after the engineer has passed the order, he also did not do it. The system did not do it. Now, my lord, I tell you also the judgments, my lord. Then I will give a after his clarification. I will pick up in my the last page. So, judgment by second, I will record it. Yes. This is actually judgment is not in the process by ECMA. But I ECMA. Ramdan Khan is ECMA. Bottom citation 1994 SSC. Only one line I will show from this. Para 28, page 755. One line. Page 755.
Yes.
Last line, last 3 lines. Now the disciplinary authority has to consider the representation of the employee against the report before it arrives at its conclusion with regard to his guilt or innocence of the charges. As your lordship is directed in their judgment, my lord, exactly same thing. This is the second law, my lord. Next is, my lord, about the power of the lordship, my lord, in such proceedings, civil proceedings, my lord. This is 2020 SEC on my 886, my lord. The relevant page, here will be, my lord. Last part 3 page, my lord. Last part 3 page. What is this one? There are 39, my lord. Last part was 4 page. There are 39. My lord, this is by Honorable Chief Justice, President Chief Justice Chandra Chode, my lord. My lord. There are 13 Russians got it, my lord.
Yes.
Can I read my sister? In exercising judicial review in disciplinary matters, there are 2 ends of the spectrum. The first embodies a rule of restraint. The second defines when interference is permissible. The rule of restraint constricts the ambit of judicial review. This is for a very reason. The determination of whether a misconduct has been committed lies primarily within the domain of the disciplinary authority. The judge does not assume the mantle of disciplinary authority, nor does the judge wear the head of an employer. Difference to a finding of fact by disciplinary authority is a recognition of the idea that it is the employer who is responsible for the efficient conduct of their service. Disciplinary authority inquiries have to be abided by the rules of natural justice, but they are not governed by strict rules of evidence which apply to judicial proceedings. The standard of proof is hence not the strict standard which governs a criminal trial of the proof beyond reasonable doubt, but a civil standard governed by a preponderance of probabilities. Within the rule of preponderance, there are varying approaches based on context and subject. The first end of the spectrum is founded on difference and autonomy. Difference to the position of the disciplinary authority as a fact-finding authority and an autonomy of the employer in maintaining discipline and efficiency of the service. Then next time is important. Is important. At the other end of the spectrum is the principle that the court has the jurisdiction to interfere when the findings of the inquiry based on no evidence or they suffer from perversity. But at the end of the at the end of the spectrum is the principle that the court has the jurisdiction to interfere when the findings in an inquiry are based on no evidence or when they suffer from perversity. I will say perversity. Why? Next slide. The failure to consider a vital evidence in an incident of what the required regards as a purpose determination. This is what my in my reply, I have stated 1, 2, 3, 4. Although my reply is very deep, so that's why I'm given a page my in those pages and then my written argument also. Specifically given the page but for the also convenient, so my market can also reply. So this is the purpose. Because I give it also directed that they should consider reply. I give a reply. You pass a judgment. If you order, other person those facts find it. So my case is already covered by this judgment. That's what I'm saying. Next is my word. Small place, small government. My lord, this is a commandant. My lord, command plus what is my lord? Name of the party is commandant, 22nd battalion. My lord, there are last paragraph, small paragraph. I won't trouble much. Moreover, it appears from the impending order that High Court has in exercise of power of judicial review, interfered with the punishment of dismissal on the ground that which was disproportionate. In India versus R.K. Sharma, ASSR, this court has taken the view that the punishment should not be merely disproportionate, but should be strikingly disproportionate to warrant interference by the High Court under Article Constitution. It is only in the extreme case where on face of it there is a perversity or irrationality that there can be judicial review under Article 26. That's what I say. Perversity, irrationality, exactly my case. That's what this doesn't like. The next is my lord. My lord, our High Court judgment, my lord. 2017 4 GMT. Jamuna. I don't only one paragraph. Last paragraph. There are 59. Last page.
Yes.
Consequent upon setting aside of the order as above, the petitioner should be reinstated in service with full back wages. While directing so to rely upon a decision of the Supreme Court in Dipali Kundu Sarvai. My lord, Roshiva Sriman, for the common one, the petitioner's name is Dipali. Yeah, this case also Dipali. This common. Dipali. Wherein, in paragraph 22, Supreme Court held that very idea of resorting an employee to the position which he held before dismissal or removal or termination of service implies that the employee shall be put in the same position in which he would have been, but for the illegal action of the employer. The injury suffered by a person so dismissed or removed or otherwise terminated from service cannot easily be measured in terms of money. Supreme Court held that reinstatement of such an employee, which is preceded by finding that action taken by the employer buyers, the relevant provisions or principal nature of justice would entitle the employee to pay back wages. If the employer wants to deny back wages to the employee, then it has to specifically plead and prove that during intervening period, the employee was gainfully employed and was getting the same employment. Denial back wages to an employee who has suffered due to the illegal act of the employer would amount to indirectly punishing the employee concerned and rewarding the employer by relieving him of the obligation to pay back wages during the employment. One more question. That is by our High Court final.
Please.
Last part one page. Last part one page. There are in other words, the requirement of law is that before a decision is taken by the disciplinary authority, whether inquiry report has to be accepted or not, the delinquent has to be given a chance to make registration against the report submitted to the officer. After all, report of the inquiry officer is one of ministerial documents, material documents to be taken into consideration by the disciplinary authority before accepting the case or otherwise of the delinquent. Therefore, as explained in the principal natural justice requires that before such decisions is taken, the delinquent is required to afford the opportunity to make his statement by way of investigation such report. Therefore, it is for the disciplinary authority on the basis of the material record, including the inquiry report, and the response of the delinquent to take a decision as to whether the delinquent is guilty or not. Once the disciplinary authority holds that the delinquent is guilty of misconduct and decides upon impose penalty, no fresh trouble provision is different part. This is after my reference to amendment. Now I can see that there are control. Since we have held the interim penalty order legally unsustainable on the ground of violation of natural justice, and also by taking the view that there was no misconduct on the part of petitioner Stix and so, we do not consider necessary to deliberate upon other grounds as well. After setting aside my lord, Honorable would stop there. Then you don't go ahead, my lord. Just last line I feel like one sentence. Yes, yes. Sir, last line of earlier page. Before parting with the record, we may observe that we can sorry that the senior judicial officer had to suffer this cordially. That too, at the front end of long service area and had to subordinate from service equality. We say only this, no, my lord. That's all, my lord. Here is the decision of my lord. After all this thing, she is now what I received from her, finally, what is my case of the I give my comment there, please to ask for time something. Whatever may the consideration the case, so in our part, whatever was possible, should accept it.
Bali Subhase case which was referred to, just refer that case in another court.
Third, Mr. Abhinav, senior counsel, assisted by
DJ copy.
DG Kapil and the counsel for petition. On request made by R. Madhunda. The standing counsel, the paper individuals. This the matter again of when
Next is the so that
21st.
my lord, Boston mechanic is part of it because last time it happened, my lord. After allowing a lot, my lord, somehow that pattern has not gone there. And this case is going to this court and that court, my lord, we suffered a lot, my lord.
Yes, got it.
Yes, sir. I know that's my question.